wherever you are, therefore shall the jurisdiction be executed. Everybody, welcome to the stream. I'm not sure if he's actually in the stream.
I
Artie's
am in the
corporate
stream.
fiction. You are very there you are.
Yay.
Hey,
Okay, yay. Nice to see you.
hey, good to see you too.
Welcome. Bienvenido. How are you?
Good. I just got back home from work like about 10 minutes ago.
Oh damn.
So
I feel you. I obviously I'm still in my suit.
yeah,
I started this directly from work, so just hopped right on. Thanks for joining us.
And
Right,
not and
coming
not
right
for
from
nothing,
work.
like the question of what countries there are in the world is at some level a matter for each country to decide, because if you get into the question of like how many countries are in the world, you get into disputes because not
That's
every
right.
country recognizes every other country. The United
hmm
States does not recognize some places in the world that other places recognize. For example, Palestine might be perhaps the most notable. Palestine is recognized by some countries. The United States does not recognize Palestine as a place that exists. So as far as they're
Mhm.
concerned, there is no such place. And there are a
Right.
lot of other examples because there's all kinds of like countries depending on who's counting and who's keeping track of such things.
of course.
So first of all, the United States does not recognize your country. So it doesn't exist as far as the United States is concerned. So that's kind
Mhm.
of the end of that analysis. So yeah. Second of
Good luck.
all, you visited our country and you're here now. So there's that.
Mhm.
You committed the crime in our jurisdiction with the riding over the people in a car.
Mhm.
So yeah.
So you're not rating his chances as very high of being found not guilty because
No.
the court does not have any jurisdiction over him, Kurt? Is that what you're saying?
I'm thinking he's going down and he's going down hard.
Okay, well, let's get a look at how Mr. Brooks is dealing with the slow train of justice marching its way ever towards him as he sits on the tracks, unable to leave despite his best efforts, despite
Yeah.
everything he's done thus far.
And
I am
people
going
asking questions in chat, just assume the answer is varying degrees of stupid. Like Kiki asked, why is he not recognizing his name? What difference does it make? Well, I'm
ah
so glad you asked. These are the people. These are some of the people who think that their name matters, or sometimes it's if their name is all caps versus
Yeah.
not all
mhm,
caps or whatever. That their name in some version of it is a legal entity that's been imposed on them from the outside,
yes.
and it represents, they are not the person, they are a corporate trust that represents the person or something. It doesn't make any sense. It's all varying degrees of stupid.
So it's the straw man, and I think
hmm
Artie has some of the best insight on this because he and I have gone toe to toe with some of these guys.
Oh
Yeah.
yeah.
Here
Well, we
live
can we
on
can call you
YouTube.
John Doe if you like. It'll make no difference.
It makes no difference whatsoever. Artie, give us a little breakdown of the straw man argument, if you wouldn't mind.
So
Okay, and why they
Oh,
don't want to use
please.
their name and all that. It's such a it's so intricate and interesting.
so it really, I mean, it depends. It depends on which guru you talk about, but generally, the straw man or redemption theory, is what it's also called, is the premise that there are two versions of you in the eyes of the state. There is the flesh and blood, me right here on camera version, no, known as Artie. Well, that's not my real name, but putting that aside. And then there's Artie, who's known by the state. Artie, who is on paper, who's on a birth certificate, my driver's license, on any sort of legal documents. That they believe that the straw man, that is your straw man, that is your uh, doppelganger in the eyes of the state. And so, what a lot of these gurus or sovereign citizens believe is that you are able to place all your liabilities on the straw man while keeping your flesh and blood self, free and clean. And by liabilities, that can mean anything from debts and obligations to criminal actions. So that's a very Cliff Notes summary of what a straw man is that you're able to set this created entity to uh, take on all the problems that you have while keeping yourself A-okay.
And I just got to ask, the guru's language, is that from Meads and Meads?
Yes. Well, Justice Rook, who did the Meads decision, he did the treaties, basically. A lot of courts in the U.S. have also done like breakdowns of the redemption theory. The one actually I think I know of is one of the ones that was cited by the court here, the U.S. versus Banabe. I call it Banabe, but I've never heard it pronounced out loud, so that's how I pronounce it in my head. The Seventh Circuit decision that talked about sovereign citizen and redemption theory. But the Meads decision was a Canadian case in 2012 where it was a massive breakdown of what Canada calls like was it organized pseudo legal commercial arguments or something like that.
Yeah.
And I look to that case every once in a while again because the judge breaks down all the different variations of the group, whether it be from like the patriot angle to the hyper religious angle to the Moorish or Aboriginal angle, and then he actually calls out by name a number of the well-known gurus of the time in that decision. So Meads is a very good resource in and of itself, that single decision.
Well, and Meads is also Justice Rook is in my local area. It's an Edmonton decision, so I've appeared in front of Justice Rook.
Oh wow!
You should get him for an interview on the subject. That'd be fun.
That would be awesome.
Judges and justices are really reluctant to do interviews.
That's true. Fair enough.
It would be unlikely, but if I could, it'd be fascinating.
That would
maybe
be
awesome.
Maybe
I'll send in a media request and they'll deny it.
Yeah, I wish I could get one of my judges on my channel, but I just know that like I can't, like they're like, oh, it's favoritism, you went on her YouTube channel, so I could never do that. But I would any of them, I would just love to like pick their brain on certain things. That would be great. All right, guys, that's some awesome commentary. Thank you so much for that. I need to mute myself. You guys go ahead and keep talking, and let's get this playing. I'm gonna play it a little bit fast until we start getting to where Mr. Brooks is going to ask for the grounds for the objection, which is very, very entertaining. And this testimony is quite compelling. It is the testimony of the individuals who were present as the car was mowing its way through the Christmas parade with babies. What are you thinking, man? All right, let's go.
Those decisions, I believe they speak for themselves, and your request for any further articulation by this court as to the basis for the court's decision is denied.
May I respectfully object, Your Honor, and still ask for verified proof of...
Mr. Brooks, I've already addressed that the request is denied. All right, moving on. Can the state, I'm moving on, Mr. Brooks. Thank you. Your objections are noted. Attorney Opp, I'd like to address the issue.
Your Honor.
Your objections noted. I would like to address the issue of the subpoenas that were turned over to the state. If you could just make a record on that.
Yes, thank you. We have received the subpoenas that were provided by Mr. Brooks. I believe there were 12 in total. We are endeavoring to have all the individuals properly served.
So uniquely here in this case, the prosecutors are helping Mr. Brooks to have his witnesses served. Usually, and again, it's not because they're super nice. It's because they're trying to protect the conviction, protect the conviction from being overturned on appeal. He didn't start representing himself until about 2 or 3 days, business days, before the trial started. So he has not served anyone. People are getting served while the trial is going on. And obviously, he's not going to know how to do it. So the state is helping him.
And we will assist in arranging their appearance here in the courtroom at the appropriate time, with the exception of that one individual who we believe has relocated to the state of Texas. There are no other concerns that the state has at this point in getting those subpoenas served and getting these people here. I do want to advise the court that one of the witnesses on Mr. Brooks' subpoena list does need a Spanish interpreter. And that also reminds me to update the court on our progress in that regard. For the state's case, we believe if we would need a Spanish interpreter, and it's still unknown to us, or uncertain, I should say, it'd be later tomorrow morning, like probably after the morning break or even after lunch. We could call these witnesses out of order if we had to. So if you want to just say possibly 1 p.m. tomorrow, we could certainly work around that. And then when we get to Mr. Brooks' case, one of his witnesses will need an interpreter as well. We'll try and help the court keep track of that as well.
Have you been in contact with the individual at the clerk's office that assists with making arrangements for the interpreter, since it is the court's responsibility to do that, but it's your request?
I know my assistant had spoken to someone in the clerk's office. I think it was last week. I don't know if there's been any recent contact, but I will ask her to do that today.
Well, I know I saw one of our interpreters yesterday, and I don't know if that's because of those arrangements or not. And I don't see that person here today, but
yeah, I saw him also. I think he just came in to observe for a while.
okay. Can you tell me the name of the witness for Mr. Brooks that needs an interpreter?
Juan Marquez, Marquez.
And this, can you just give me a little bit more background? What I'm contemplating is, because I need to make.
All right, I'm going to skip us through to the witnesses where they start testifying.
What are these 13 witnesses? Do we have an offer of proof as to what these 13 witnesses would offer?
No, we don't. And they're not going to stop him from calling whoever he wants to call. They're just not going to do that. They're going to let him have wide latitude. She, the judge, cut him off from questioning the girlfriend, his girlfriend at the time, who he allegedly assaulted before he proceeded to ram through the parade. She allowed him to ask the same questions over and over and over again before she exercised her judicial discretion to stop him from questioning her, because under the rules, it became badgering, right? So she's going to give him as much latitude as she can to call as many witnesses as he wants. And my understanding is that most of the witnesses that he's putting under subpoena were at one point like state witnesses and things like that. So no offer of proof as to the relevance of these people, nothing. It's going to be a free-for-all.
That's good.
Case. Yes, but it protects him, right? He'll never be able to say, I didn't get to present the defense that I wanted to present. That's never, ever going to happen here.
You know, if I ever become a trial judge, I'll have cameras in the courtroom unless it's a sovereign citizen, because I just don't want the camera seeing me rolling my eyes that hard.
I mean, it's hard to control your face when, you know, this is a completely serious case and absolutely ludicrous questions are being asked. Many of them are just on their face irrelevant, you know, because they go back to a sovereign citizen ideology.
You think?
Yeah. Let me let you guys get a taste of that. If somebody wants to, I know Rob says that he's having a hard time stomaching this. Thank you for the super chat, Rob. I did share that on the channel. If somebody wants to share the link with Rob, please, I would appreciate that. I don't know if you guys can do that from where you are. If not, I'll just put it in the private.
I'll send it to him.
I can send it to him.
Much appreciated. I'm going to mute myself and get us started with some of this testimony so you can hear him requesting the grounds for each of the state's objections.
What injuries, if any, did Adelia sustain?
Massive bruising all up and down her back. She
Was the relevance of showing the video to us?
Browns. And we'll play from the beginning.
That was a fair question. On what grounds was it overruled?
And let's pause right there. At 3 seconds. Do you see yourself at this 3 second mark?
Yes, I do.
Just tell us where you are in the screen.
We're directly in front of the black shirt band banner. Adelia is wearing a red cape shawl with checkered, black and white checkered leggings. It was really cold and windy that day. And then I have the candy cane dress on with my jacket and a hat and candy cane leggings.
And what does it appear at this moment that you're doing with Adelia?
Giving her more candy.
Let's resume. Pause.
They're not showing the
Paused at
video?
the 19-second mark. Do you
Okay.
see yourself in the video at this point?
Yes, I'm lying directly between both of the vehicles.
The screen in front of you is a touch screen. Would you mind circling yourself? Your Honor, I'd ask to to save the screen of 22 and mark it as 22. I think we're on
22B.
Yeah. So that 22B would be marked as, and I would move that into evidence.
The screen will be captured with the annotation. It will be marked as 22B. And it will be received.
Let's resume at that point. Pause. And we've paused at 24, and we can take that screen down now.
Is it okay with you guys if I fast forward a bit to where Mr. Brooks is doing the cross-examination? Because I think
Sure.
that's okay.
Yeah,
I go ahead.
I was gonna say I think I saw a little bit of the direct here. I didn't see any of the cross. So
Yeah, okay. So let's go to suffice it to say, everyone that testified was either struck by the vehicle or in the vicinity of people that were struck by the vehicle. The little girl that was hit did not pass away. It was a little boy that passed away. But I think that you'll get kind of more of a feeling of how he responds to the state's objections. And I think it was Runkle who said, that's asking for the grounds for why something was sustained, is fine. But, as I understand it, the convention is normally you would ask to approach, or you would, you wouldn't ask the court asks you for the grounds for your objection. The opposing party does not ask the opposing party for grounds for their objection. That is the court's job to ask for those grounds. You can ask to approach and say, Your Honor, I don't understand why you're, overruling or sustaining this objection. But you don't want to look, and I don't know if that's a convention thing, but you don't want to really look like you're quibbling with the judge in front of the jury. Like, that's not very helpful to your appearance in front of the jury. I would love to hear anyone's thoughts on that.
I mean, where I am, if you want to object to something, you typically have to get up and the jury is let out each time, and then you make your objections in open court. So there's none of this approach the bench stuff. It's just jury out each time, which when you're running a jury trial means you've got to be really careful with what you're saying, because if you're cross-examining a witness and you leave yourself open to an objection, it really breaks up your flow badly.
That sounds terrible, by the way. That sounds very, very cumbersome. But in a state that doesn't allow speaking objections, and I'll have to look and see if this state is one of those that allows it or doesn't allow it. You're not supposed to state the grounds for your objection in front of the jury. Or in front of the witness, because it kind of leads the witness basically and is arguing things in front of the jury that they really should not be considering. So we're not supposed to do speaking objections in front of the jury. If you want to state the grounds, you can approach to state the grounds. Sometimes we have little headsets to state the grounds or something like that, or the judge might waive the rule on no speaking objections. So I know that it varies, jurisdiction by jurisdiction, but I've never heard it's just highly irregular for a party to say, for one party to say objection and the other party to say grounds, because that's not your job. That's the judge's job.
No, it's just she's sustaining the objections, and I don't know if he actually understands what's being objected to. That's where I was saying that this is fair, is that he should understand the basis.
He's pretending not to understand.
Yeah, he is pretending, but you don't want to have him with an appellate issue there.
Right. On the record, they'll say he didn't understand, right? Yeah. Now, there's another question. Did you assume that risk by deciding you were going to represent yourself? The judge told you.
More than somewhat.
Yeah, the judge said to him during the qualification There will be things that you won't understand. You do not have the training to do this. These lawyers are eminently qualified to represent you, and you don't have the training they have. You don't have the preparation that they have. They've been sitting with your discovery for months. You haven't been, you know? And so, do you waive that by electing to represent yourself? Is also a question I have.
So you did hear shots fired. Did that
I
come
don't
from?
know if it was directly from a cop or if it was people running.
Did you hear the shots?
I did not.
So after you were struck, it would be fair to say that it got louder than what it was before.
After, in the middle of the complete chaos, yes.
With all the noise and chaos going on, do you think it would have been hard for you to hear a horn honking?
I did not hear a horn.
Would it have been hard? The question was, would it have been hard for you to hear it?
Before it got to us or after?
After it became chaotic.
I was not listening for a horn after we had already been hit by the vehicle.
So it'd be fair to say you wouldn't be able to recall.
I would not be able to recall that.
Did you file any claim in this incident?
What do you mean by claim?
Did you file a report as an injured party in this matter?
This is the sovereign citizen bullshit. This is it. In a 6-person murder trial, did you file any claim as an injured party? Artie?
She doesn't have any claim.
Sorry, Artie. I hate
She doesn't have any
to
claims.
but you're the best at breaking down their reasoning.
So part of sovereign citizen ideology is the goes to the idea that for there to be any actual, well, there's two elements. One is for there to be an actual crime, there has to be an injured party, be it somebody who has suffered an actual physical injury or some sort of financial loss or property damage. That's number one. Number two, the reason why he's asking if you filed a claim is that, again, because Mr. Sovereign citizen ideology rejects the idea that a state as a public entity can prosecute on behalf of the people or prosecute its own crimes because it's a corporation or a non-living being. The only people who can file claims against another human being is another human being, aka, in other words, according to Mr. Brooks, it should not be the state of Wisconsin versus Mr. Brooks. It should instead be the estates of the 6 individuals who passed away and the other 60 plus people who were injured when he ran them over versus Darrell Brooks.
That's right.
So that's why he's saying, did you file a claim as an injured party, et cetera, et cetera, et cetera?
That's right.
It's not how it works in criminal law at all.
No, but I mean,
we often talk about victims pressing claims or pressing charges, but strictly speaking, that's not a thing. Victims don't press charges. You can file a police report, but you can't press charges. That's the only person that can press charges is the prosecutor.
That's right.
I think it's very rare. I can't recall if there's might be one or a tiny handful of states that actually do allow you.
Virginia used to allow you to. I don't think they do anymore, but they did used to allow you to in some circumstance.
Yeah,
Maryland is one of the minorities. We have what's called a civilian complaint, where say it again.
Canada does as well. You can bring a private. They don't go anywhere, but you can bring one.
Yeah, so I can go to now again. There's a balance here. There's a check because ultimately, if it's gonna go to trial, it's a prosecutor trying the case, right? But I, as a citizen, can approach a commissioner who is not more than likely an attorney, is definitely not a judge. And is an elected official, and I can say to that commissioner, Kurt came to my house and slapped me in my face. Kurt's never been to my house. Kurt didn't slap me in my face, but I can just go to the commissioner and just say it because I feel like it, because I'm just bad-minded that day. And the commissioner will say, well, a slap, that's an assault. So I'm going to charge Kurt uncivil law with assault. And it'll be the state of Maryland versus uncivil law for the charge of assault against Natalie Lawyer Chick. And then hopefully, you would hope, the prosecutor would then go and do some type of investigation. Maybe even law enforcement would. But more than likely, what will happen is the case will be set for trial in the district court for whatever county that charge was taken out in. And you better appear, because if you don't, you'll have a failure to appear. And you will be prosecuted by a prosecutor who likely has never spoken to you before. We'll just see if I show up in court, put me on the stand to point at you and say, uncivil law slap me, with nothing other than the complaint of a civilian. So there we are in the minority in states, and we allow that foolishness.
My name is uncivil. Assumption of risk.
Hey, look, you knew what I was about when you met me. I told you who I was the first time. You should have believed me, Natalie. And that's how you get slapped, you know? That's just what happens sometimes. All right, let's keep it moving.
Yes.
So it would be fair to say that you identify yourself as an injured party?
I was injured by the circumstances that day, yes.
Good for you.
Do you recall the officer that you reported your claim with?
I do not recall.
Have you seen or read a complaint in this matter?
What do you mean by that?
Have you seen a written complaint or read a written complaint in this matter? Objection. Grounds.
You mean the indictment?
Mr. Brooks, are you referring to the criminal complaint in this case or something else?
I'm referring to something else, the complaint.
Well, then I'll sustain the objection. As to the form of the question, it's vague.
May I respectfully ask on what grounds, Your Honor?
It's vague.
She just told you vagueness.
Next question, or rephrase.
Do you know of any complaint being filed in this matter? Objection. Grounds.
Sustained.
If
I do this.
If I wish harm against him, will everyone understand that it's not lynching because of his race and it's because he's a jackass?
Okay, Kurt, no. Bad Kurt.
Kurt, I'm gonna get the water bottle and
Bad. Spray. Bad Kurt.
I just thought I'd also I mentioned that Canada allows private prosecutions. I think you'll probably find it wild how they go. So in Canada, if I bring a private prosecution against somebody, there's a little miniature hearing to determine if that should go forward. And the Crown will usually stay it before that happens. But if not, then I bring whatever evidence and they determine if there's enough for it to proceed. And let's assume that I bring enough evidence that it proceeds, because the test for that is pretty low.
Yourself as a private citizen.
As a private citizen.
Interesting. So you have to bring your own proof.
If I'm launching a private prosecution, then yes. Normally prosecutions are launched by, the state or it'll be the king and so. It's the government of Canada proceeding with the prosecution. But if I'm doing it personally, then I have to bring my own evidence to this little thing, which could be, just I get up and testify, Kurt slapped me.
Mm-hmm.
Now, if they determine that there's enough evidence for it to proceed, the Crown can, kill the proceedings, or they can continue on, do an investigation to determine if there's any more evidence. If there's no evidence and they don't think that there's enough for a prosecution, they can withdraw it. But if they do think there's enough evidence, they have an option. They can take over the prosecution, in which case it's a prosecutor who runs the file, or they can say, Runkle, go to town. And so there's theoretically a possibility that I, as a private citizen, can be the prosecutor in that case because I launched the claim.
That is
Which
fascinating.
It never happens, but it's wild
Thank
that
God.
it's a possibility.
Thank God that never happens. Artie, do you know of any, or Kurt, does anyone know of a state in the United States that does that? Now, I know that civilians can bring complaints, but then the prosecutor prosecutes the case.
Of the very, I can't recall with maybe Kentucky does the private prosecution. Like, I don't know, but of those that I know, they do not let the actual plaintiff bring in and actually conduct the trial. No.
You know, we love Canada for the universal health care and everything like that. But the more I'm learning from Runkle, the more I'm finding out you guys are a little wild up there, huh?
The thing is, this is a theoretical possibility, but it never happens.
Can I send him out onto an ice sheet?
That's not an option. That's known to law. But it's basically what'll actually happen with a private prosecution is either they go, yeah, holy crap, we should have proceeded with this ourselves, and it'll be a prosecutor who handles it, or they'll withdraw it. I have never even heard of them letting a private citizen run it, but theoretically they can.
Yeah.
And
I also
go ahead.
Just briefly going back to, and again going back to his current cross-examination of her about the whole complaint
that's
and
where I was about
inter-party
to go.
bit.
So yeah, go for it.
To add on to what I said earlier, the sort of like no injured party thing, that sort of thing, that's the kind of thing you would think would apply, or that they would try to argue in a traffic case, right? For a speeding ticket.
Right.
For him to try and pull this in a murder trial just makes it ghoulish, because there is an injured party. There are injured parties, but for him to stick with the script, as it were, just makes it that much worse.
Right. So what I'm trying to impress upon you guys is that these questions sound wacky. They are wacky, but they're a part of a rubric within the sovereign citizen, ideology, that there has to be an injured party, that it's basically akin to like a civil claim instead of a criminal claim, and it's not valid unless it's that person versus them, that they're not in the jurisdiction of the court, that there's not actually a real complaint, because usually they're talking about traffic tickets. And even when they're talking about traffic tickets, they're wrong. They're absolutely wrong about the law. They're just completely misinterpret everything. They're trying to, apply some archaic beliefs that they have to an actual legal system. But then you take that and apply it to a criminal multi-murder case. They're just so much more wrong that it just sounds completely ridiculous. And another question people had was, why does he keep yelling grounds? Why does he keep yelling grounds? He keeps yelling grounds because he's heard the judge ask him, what is the grounds for which he is objecting? Why are you objecting, sir? And so now he just thinks he's just going to sit. He doesn't know what it means, because even when the state says the grounds, they'll say, well, this is leading, Your Honor, or this is, irrelevant, or, this has been asked and answered. He'll say grounds. The grounds have been stated, sir. And you'll hear him do it over and over again. He doesn't know what it means.
Yeah, I always
got some grounds I want to show on.
Like sovereign citizens are kind of cute when they're in traffic court going, I don't need a license plate. But when they show up in, the line I've used is when they show up in 268, which is the local domestic violence courtroom, arguing the same stuff. It's like, it is a lot less cute. And now we're talking about a murder trial. So
yeah. You want to hear something crazier, Runkle? Our domestic violence courtroom is 262. Yours is 268. That's just a funny little coincidence. It's very interesting. So sad.
These guys are just such a headache. And this is what part of the pitch I'll make. If you're going to law school and you want to do, you're trying to decide what to do, go into criminal defense, because you will almost never have to deal with these guys, because they don't want a lawyer. And but if you're in prosecutions, they got to deal with them. If you're in civil stuff, they got to deal with them. So criminal defense is really this little bubble where you will almost never have to encounter these guys, and it's wonderful.
The happiest lawyers in Wisconsin right now were the ones that were discharged from this case because he didn't want them. You know, they'll never say it because I'm sure they're
You're
eminent
cracking champagne
professionals.
on the courthouse steps every day.
I watched them walk away. Your Honor, are we excused? And that man was sitting, they got up and they were out of the courtroom, gone, you know? And so those are the happiest lawyers alive right now.
I bet those people are in their office right now because they would have had this big block of trial time scheduled that's now clear. I bet they're having a watch party with like champagne on one side and popcorn on the other, just going, "Yep, this is the best thing ever," because we're not in it.
Oh, I'm sorry. Just give me 1 second. Somebody legally Leah. All right, I'm gonna share this. Kurt, legally Leah says Kurt needs to apologize for joking about lynching on a Black woman's platform. The caucasity is appalling. I'm not laughing. I can't not address it. I'm sorry, Kurt.
Are you asking me for an apology?
No, I'm just saying that's what she said. Let me put it this way. I apologize if you were offended. I don't believe that Kurt meant to offend you, but I don't think it would be fair for you ask me to address it and for me not to address it. And so I saw your comment, and I'm sorry that upset you. I don't know what the right answer is there, and I don't think that I really know what to say. You know, I took it as a joke, maybe in poor taste, but I guess other people did not. So I'll leave it at that.
At the risk of explaining the obvious, it's obviously because he's so absolutely infuriating to me that, you know, I just want to reach up and like, you know,
yeah,
you know, he drives I have no compassion for him. You know, I have no compassion for him at all because he's a 6-time murderer, you know, who is wasting everyone's time and causing harm to all these witnesses, causing harm to them by making them go through this circus. He's continuing to cause harm to people. I mean, he's actively at this moment continuing to cause harm to people. He has no compassion or sense of empathy himself. And it's like, you know, so it makes my blood boil a little bit. So, okay. I mean, if the language was a problem, I apologize for the language. But it's just like, you know, I was just trying to express the sentiment that he makes me want to, you know, just he doesn't bring up my better angels, I suppose.
Yeah. I'll just say that I maybe am failing in this moment because I just don't know what the right thing is to say is. I don't have a lot of sympathy.
But I mean, it's your it's the reason I asked if you wanted me to apologize is because it's your platform, and I don't want to offend you. And if it offended you, I'd apologize to you because I don't want to hurt my relationship with you.
Yeah, I understand, but also like, I guess people watching this, and like, I'm just never one to like shy away from anything, but like people watching this don't know that we're friends and that, you know, I just, you know, I have a friendship with you, and I think we've supported each other and things like that. But when people don't know you, they don't know you. And I don't really know what my role is in that. Like, I didn't say it, but you're here on my platform, and I thought that it would be. I thought it would be. Hold on, don't say anything. Hold on. I thought it would be cowardly of me to see that comment and then just be like acting like I don't see it. You know, like, because then other people were saying that they saw it, and I thought that would be cowardly of me not to say anything. And then I think that's it. If you guys want to discuss it at a later time further, I welcome you to the discussion, but I would just prefer to just continue with reacting to the video. But I understand if you're upset and you want to leave because, not you, Kurt, if you guys feel upset and you want to leave because you're upset, I understand that. And I don't judge you in any way, but I'm going to move on. And, you know, I'll move on. Okay, thanks. And I also, I'll also think some more as well. Maybe, like everybody wants to react in the moment, and just sometimes that's not the best thing to do. Sometimes it's better to just like think and talk and then, react later. And you guys are free to have whatever thoughts that you want to have. I thought that Kurt moved on from it quite quickly, and so I thought that it was over, but I don't want to not recognize what you guys are saying. Okay, guys, let's move on, please.
Grounds.
That's the form of the question.
Were you aware that it may be possible that you could give testimony in this matter?
Yes, I was aware of that.
Did you seek to give testimony in this matter?
I was okay with doing so.
And who were you informed by?
The district attorney's office.
Was that in form of a subpoena, or was it a conversation? Or
Well, at first it was knowing that there was a possible.
Brooks is getting the grounds. I don't know if you guys, my thing said my mic was disconnected, so I don't know if that's right or not. But
I was like in a middle of a bit of silence there for the last minute and a half.
Okay, can you hear me now?
Yeah, I can hear you now. But
okay, yeah, something was going on this end because it said mic disconnected. But anyway, Mr. Brooks is saying grounds, but they're saying basically relevance. What is the relevance of whether or not she's seen a complaint, right? And the judge has allowed Mr. Brooks to have quite some leeway with this. So this rule she's invoking is a rule that we talked about in the last stream, where the judge has the right to shut down the cross-examination if it becomes overly repetitive or harassing and for other reasons. Thoughts, anybody? Uh-oh. I feel like I'm losing people, but I can't really tell.
He just seems like he's aimlessly wandering. I mean, he hasn't really been harassing yet. It's just at this stage, he's just kind of clueless.
Yeah. I mean, well, I don't know if he's clueless. I think he's trying to push forward this sovereign citizen stuff, and it just doesn't work,
Yeah.
Yeah, I don't know. All right.
Not hearing anything.
Yeah.
Nat. We're not hearing anything. It's really low right now.
So are you bringing this claim against the accused defendant in this matter? Objection, grounds.
Sustained.
On what grounds, Your Honor?
It's vague. That's the form of the question.
How now?
Yeah, I was hearing it now. Yeah.
But no echo?
I wasn't hearing an echo now.
Okay,
Well,
all right.
Have you seek to receive any recovered damages or anything in the matter?
Yeah, it sounds like the sound.
We got was help to pay for our medical bills, as that was something that was completely unexpected from a Christmas parade.
Is that through the state of Wisconsin?
I It was through, I forgot the name of what it was.
Are you listed as a plaintiff in this matter?
Am I listed as a plaintiff in this matter?
Are you a plaintiff? Did you
Not how
file a
this
claim?
works.
Objection.
Other level question, sustained as to the form of the question. Mr. Brooks?
Did you file a claim?
611, move on. You've already asked about whether she filed a report. Move on.
Do you see the state of Wisconsin present in the court? Objection. Grounds.
Sustained under 90611, I warned you to avoid that topic, or I would cease cross-exam, so I'll give you one more opportunity to ask a different line of questioning.
Okay.
Also, yes, I do see the state of in the court. First, in the role of the prosecutors, and second, we're in the state. All of this is the state, like is part of the state.
Well, according to them, there's no such thing. If so, their name should be on the other side of the verses, not this fictional entity.
Hey, Lawn Lumber, how's it going?
It's going.
This is the one that you said it's been hard for you. Listen, tell me why it's been hard for you. While you're doing that, I'm gonna try to figure out what the heck is going on with my screen share, because people were saying they couldn't hear anything anymore. So I'm gonna try to restart that. All right, so go ahead, Rob. Why has this been hard for you?
Oh, it's so this case sucks. He is struggling so very terribly, and you can see the frustration that he's having. And there's a part of you that's like, oh, you're struggling, and I can see the frustration, and I know that it pains you and you don't like watching it, but then you also see the victims and the witnesses that have been insanely well prepped, and they struggle in their direct to get the information out. You can see they're holding back tears or holding it back and keeping it together really well, but then you see him testifying or him asking questions, and you're just like, oh my God, please stop, please stop, please stop, please stop, don't ask that. And he just does.
Yeah, it's hard. I mean, I know, Rob, most of your practice is family practice, but you've done some criminal defense, right?
Just a bit, yeah.
Yeah, and I feel like when you have done, and I know Runkle's done it, or does it, when you have done it, and it's kind of off-putting to some people for a defendant that they find to be so despicable. It is hard to see somebody torpedo their own case like this. You know, when there's so many protections that are put in place to try to help someone. I don't know about you. There have been moments where I'm like, oh my God.
And you feel conflicted, like you feel internally conflicted, because you're like, this is a person who is reaping exactly what they've sowed.
Yeah.
They're getting their exact moment to face all of their accusers and have to deal with that. It doesn't make it any easier to watch.
Yeah.
So
yeah. And he has the right to do this. And then and on the other hand, it kind of feels like it kind of feels like when bringing up the sovereign citizen stuff, it undermines the seriousness of these types of charges to be talking about, are you the complainant? Have you filed a complaint? Whatever the case may be. And it's like, well, there's like 6 dead people, so nobody wants to hear that crap anyway. You know?
Well,
And, go ahead, guys.
it also torpedoes. I mean, he's got a potential defense in terms of, at least so far, it seems like he's occasionally been exploring that of how do you know it was me in the car? How do you know I was driving, and I wasn't like this screaming passenger in the back seat going, stop, what are you doing? Like, but if it doesn't matter how well he articulates that now, because the jury's going to see this guy as kind of a loon and kind of,
but
and it's so destructive to any real argument if he has one.
But let me like push back on that, just to push back on that for a second.
Sure.
You're not allowed to explore a defense where there's no merit. Correct me if I'm wrong, but didn't they pull him out of the vehicle?
No, they didn't. They didn't.
The vehicle ends up stopping randomly and he
gets out. He's apprehended on someone's steps.
Okay, so this is a defense he's allowed to explore because there was a time period that's there.
It's a little bit of a time period. He's discovered on someone else's steps. There's a picture of the car speeding past, and you can see the profile of somebody with a beard. You can see the side profile. You can see he has a hoodie up, and people say that's, Mr. Brooks. But if I was his attorney and he insisted on going to trial, or there was no good plea offer, which may very well be the case, it would be identity. It wasn't Mr. Brooks that was driving at the time. That's his best. Yep. I mean, that's his only tolerable argument, right? Because
some other dude did it.
Some other dude did it. It was some other guy with a beard with a hoodie on, right? And that's why they laid the foundation of the girlfriend saying that's him getting into the car on surveillance after he assaulted me. That's why they laid the foundation of, this is who the car is registered and all that other type of stuff. You know what I'm saying? So, but that would have been if they were facing attorneys that had an actual trial strategy. That's what they would be facing. Instead, what they're facing is, are you an injured party and have you filed a claim?
Yeah. No. Yeah. How far are we into the witnesses? Have we gotten to the parts where he's asking questions about you didn't run to go care for the person, you didn't run to go care for your family in that moment?
No, we haven't gotten that far yet. That he hasn't asked those questions yet. It's been a lot of like, it's been a lot of, who's the injured party. He hasn't gotten to like, because I watched some of it earlier today, and there were people like laying on the ground in the hospital, and he was like, well, why weren't the nurses treating them right away? Why were they waiting to treat these people that were laying on the ground? They couldn't have been injured if they were laying on the ground all that time. Like those. Yeah, that's really, really, really tough.
Yep.
Yeah. And the thing about, you can't advance a defense that, doesn't, that there isn't a basis for. State needs to prove it is always available. Like, they haven't proven it is because that's sort of the fundamental thing, right? Is prove it. Burden of proof is on the state. So you haven't proved identity is always available, even if the evidence turns out later to be overwhelming.
Yeah.
It's just,
Well, I caught part of this when Kurt was talking, and here's the thing: I want to bring back the guillotine for this guy. Like, I get that there's a historical context to a lot of this stuff. I echo some sentiments of wanting this person to reach the worst, based on the testimony he's eliciting, the worst punishment that we have available at the moment. It's hard to control the emotions. I think when you're watching him do this, it's really hard to control the emotions and say, yeah, it's just not easy at all. So I don't.
Yeah. And this is why we have a system of laws in place, and why our justice system is at its best when we allow those system of laws to work out. Right. So Wisconsin doesn't. I had a young lady on here, an attorney from Waukesha County, who gave us some like background and said, Wisconsin used to have the death penalty, but they they had it very early on in the founding of the country, and the Wisconsin becoming a state. They had one execution, and it was so gruesome that they decided never to do them again, right, under any circumstances, right? So just like in states where the death penalty is on the table, and if you're going to sit on a jury, you have to say that you're okay with following the law no matter what the outcome may be, death penalty or not. This is a state where this is their law, and the most he could get is life in prison without the possibility of parole, put away for the rest of his life. And so while the knee-jerk reaction may be, I can't even say knee-jerk, I mean, you're sitting here hearing him say these things and hearing the victims recount their stories, it is a testament to, and why I am a member of the criminal justice system, even though it has so many flaws, that yes, even someone who has, and I keep saying allegedly because he hasn't been found guilty yet, that's the only reason I say it, but even someone who has allegedly committed the most heinous of offenses, murdering 6 people, including a child, gets his day in court. Even school shooter Nicholas Cruz gets, on the issue of not even guilt, the issue of whether or not he gets the death penalty, where he's already pled guilty, he gets, what has it been, months now that trial has been going on? 2 months? How long? Anyone know how long?
Day 29 is today.
Day 29.
And this is the penalty phase only?
Yes.
The penalty, he pled guilty. The penalty phase only. And I personally don't, everyone knows this, I don't agree with the death penalty, right? But that's the state that he's in. Those are the laws that he's under, right? So it is hard to talk about this. And, it's hard to talk about this. But this is the risk that you run when you talk about cases where somebody allegedly took out 6 people for no freaking reason. Right?
They were speed bumps.
And my take on this,
I hate to say that, but like when you talk, one of the witnesses is going to testify to it. It's really bad. And I'm sorry, Ian, for cutting you off.
No worries. My take on this in terms of the death penalty is that they always use guys like this to sell it. Like, this is the sales pitch for the death penalty. But at the end of the day, the people who we kill a lot of are people with mental disabilities, people from disadvantaged backgrounds, especially in the US, Black people. We sell it on like, this is the worst guy ever. But then we kill a lot of other people who mostly just, and in some cases, at least, we discover, oh, wait, maybe we shouldn't have. Maybe, this person had a terrible lawyer. Maybe this person had, corrupt prosecution behind it. But, so I'm always sort of leery about the, like, this is the worst guy ever situation, because they're always going to push it and a little further until eventually, we get tragedies on the other side.
Right.
And, so I find this one hard, but that's sort of my take on the death penalty. I'm a bit of an absolutist on that.
Yeah. So you're an absolutist in which way, Runkle?
I would say, to the extent that if they brought the death penalty back in Canada, and I don't think they can, I think it's constitutionally a no-go here. Mm-hmm. But if they did bring it back and they said, hey, we want you to defend this, I'd be like, oh, it's a death penalty case. I have an ethical problem with that. I don't think I can participate in this system. Yeah. Sorry. No, this, and I think that there comes a point where there becomes a personal sort of moral responsibility not to participate in this.
Right.
And it's just like, if you're just trying to kill a guy, you can do that without me. And if you...
Yeah.
So...
Yeah, I think, I guess that, like, we've crossed the Rubicon, right, in this discussion. So I'm just going to go, let's just fucking talk about it, right? We're here. We're lawyers. We deal with these things, okay? And things got a little hinky there, but here we are. Let's have adult conversations, okay, about this, like, really serious situation, okay? It is hard not to feel the spirit of vengeance when looking at someone, especially in the beginning of this trial, where, to me, he was clearly purposefully undermining every single protection that he had with some misdirected belief that he would be able to subvert the criminal justice system so that he could get out of jail free card. Because as Artie and I know, with these sovereign citizens, they're thinking some magic words are going to cause them to avoid a conviction, right? And again, usually it's quaint because it's in a traffic case, right? But it's not so quaint when it's some guys on the road in Massachusetts with a bunch of AK-47s or AR-15s. And it's not so quaint when it's a police officer pulling people over on the side of the road. And then I don't know if you remember this case, Artie, where the guy, this father and son shot the officers and then took off.
Infamous.
They were sovereign citizens.
Yeah, it was
right?
it was in 2010. That's kind of like what kicked off law enforcement's realization of what these people are capable of this ideology.
Right.
Yeah.
Right. And so, look, let me just answer this question. News Now, Wyoming. Are you so staunchly opposed to death penalty where it wouldn't be acceptable here in your mind, or are there openings? So for me personally, even in this case, the death penalty is unacceptable. It is unacceptable for me in every single case because, as a rule, the state gets things wrong. The country, the legal system gets things wrong. It, as applied in each individual case, sure, there may be there's no redeeming qualities of this particular person and they killed all these people and they're horrible. If they ever get out again, they'll hurt more people, right? We just know that, right? But then there's some other guy somewhere who he doesn't get as much attention. He gets a crappy defense. He gets railroaded and he was innocent, factually speaking, or there were extreme mitigating circumstances here. I may be in the minority here, but I do think that Mr. Brooks probably has some really severe mental health issues. Does that make him incompetent to stand trial? No. He understands what's happening. Again, I could be in the minority here, but he really could have some severe mental health issues. I don't want to take the chance of taking the life of someone who 15 years down the line, our standards of what competency means changes. Things change in our jurisprudence all the time of what we believe is competent, what we believe is mitigating, what we believe is a real illness or a real this. And so because mores change, values change, our understandings of mental illnesses change, forensic evidence changes. You can have a case where the person, my husband and I were just talking about, a person is factually innocent, but it was 50 years ago. There was no DNA. And so circumstantially, to all the evidence, they look guilty. But then, you do DNA 50 years later, and the person was actually innocent. They couldn't have been there. Another murderer's DNA was on the scene, or, whatever the case may be. And we've executed that person. That's it. No take backsies. And so for me personally, don't agree with the death penalty. All right, I'm going to keep it moving. Is that okay?
Yeah, roll on.
I will get off soapbox now.
That's fine. It was a good soapbox. Well stated and well argued.
The law enforcement?
It was a few days after.
Would it be fair to say it was a few days or a week or so?
I don't actually remember the exact time.
Do you remember being interviewed by Detective Jeffrey Adent?
I remember being interviewed. I don't remember what the officer's name was.
Do you remember where you were interviewed?
At my house.
Do you recall if it was on November 30 of 2021?
I don't remember the exact date.
Can you recall why it took a little bit for you to be interviewed by law enforcement?
I'm guessing because of how many people were injured throughout this parade. It did take a while to get around to everybody.
Did you seek to be interviewed in any way?
I don't think I seeked, but I did inform them that I was injured, as well as my daughter.
But you don't recall calling any law enforcement or attempting to file a report?
Law enforcement that was there at the parade took people's name, and it all ended up going to them.
Did you follow up in the days after?
I don't recall if I did.
Do you recall stating that you did not see what happened to your daughter?
I do recall that.
Do you recall being left a business card by Dr. Daryl L. Williams, PhD?
Yes, I do.
Would it be fair to say that he was the one that told you what happened?
I still to this day don't know directly what happened to my daughter. I just know that she was hit by the red vehicle as I was laying on the ground after I was hit.
So it'd be fair to say if you didn't see what actually happened to your daughter, you didn't see what happened to anyone else.
Objection.
Grounds.
Characterization of the
Grounds.
evidence.
Sustain this to the form of the question.
So I disagreed with her sustaining that objection. And because I don't think there's anything ambiguous about him asking about her ability to observe. I would love to know what you didn't see your daughter, so that means you didn't, so, it might be a wrong conclusion, but you didn't see anyone else then. She can say yes or no. What do you guys think?
I'd agree with that.
Yeah.
Yep.
And so this is one of the disadvantages of representing yourself and also yelling grounds every moment. But one of the the judge gets annoyed with you and maybe stops listening to you. But that was, I think, a valid question. I don't think that objection should have been sustained.
I don't know, Natalie. Grounds.
Grounds. It's like he.
Go ahead.
I was gonna say he didn't do that in the first day of trial, so somebody or somewhere told him, "Hey, you need to demand that they tell you the basis for the objection." Just say grounds.
Which, to be fair, here's the funny thing about it. To be fair, it's a good, from a legal strategy standpoint, if the judge allows you to ask for it and the judge has to put on the record the actual legal basis that she is using to either allow or exclude evidence. I mean, that's how many times have you had an appeal where it's like an objection is made, it's not specific as to why the evidence was excluded, and you're sitting there trying to make a clean record.
Yeah. I was saying, I was kind of struggling with that concept earlier when we first started this stream. And I was saying, it's not done. We don't normally say to the judge, what are your grounds for sustaining or overruling this objection? And I might be a little scared too, but I don't know about anybody else. I might be a little scared too. But now I'm thinking to myself, well, damn,
I do it.
Why can't I know?
I've won cases
I do it.
on the.
Go ahead.
I've won cases that I lost at trial because I pinned a judge down to a ruling.
Yep.
The judge is just like, Mr. Runkle, I'm going to deny that. And it's like, okay, basis. Judge is like, well, I don't find that it was, that you made that properly.
Yeah.
Can we have some reasons for that? And you're pissing the judge off. Like, the judge does not like this. But eventually the judge puts reasons on the record. And at that point, I was just like, all right, I've got my reasons. And at appeal, the appellate court was like, yep, those were bad reasons. And I won because that would have changed the course of the trial.
Well, yeah, and I've been in CLEs, and I started doing it when I went to a CLE. There was a panel of judges, and the judge, and one of the questions was asked was, what do you do? And the judge said, you have to get the judge to put his or her reasoning on the record. And
Yeah.
you have to do it respectfully, and you cut them off and you say, Your Honor, respectfully, I have to preserve the record. It would be an ethical failure on my part if I did not actually ask for a clarification on this particular ruling. So I apologize if it disrupts the proceedings, but I do need a clarification on why this is being offered or admitted. And it would be
Right.
really funny if we had maybe an appellate advocate or someone who specializes in appeals on the panel. I don't know. Right now I see an avatar. Maybe he's grabbing a cocktail because I needed a glass of wine for this one.
I already got
Yeah,
my beer out, so I'm.
this is tough. This is really, really tough. I know that I have asked to approach. I know that I've said in district court, so not in front of a jury, because we're not supposed to say much, discuss things with the judge in front of the jury. So I've asked to approach and said, Your Honor, I'm at a loss here for why you're sustaining this objection. I don't know really where to go from here, because I think this is a valid question. I've literally had judges tell me things like, it's not my job to teach you how to practice law.
Mm-hmm.
Damn.
And the thing
On
is,
the record, figure it out.
I love that. If I get a judge who's doing that, I love that, because quite frankly, if you've got a judge who's dropping comments like that, you just want to keep those rolling. Because
Yeah.
I had a trial. The judge was being really abusive. This guy did not like my client, and so by extension, he didn't like me.
Yeah.
He was being really hostile. He didn't like that my client was getting an argument on this. And so he was interrupting my cross-examinations, preventing me from getting to where I needed to be. And so towards the end of the trial, we were taking a break before, coming out with our closings. And I talked to the crowd and said, hey, how do you think this is going to go on appeal? With all of those comments, do you think I've got a reasonable apprehension of bias argument? The crowd went, I don't want to take this to appeal. Walked in there and stayed it, which killed the file.
Wow. So the crown for you is the prosecution.
Yeah. Crown prosecutor. And
yeah.
Killed the file because first he was concerned as to whether or not my client had received a fair trial as a result of that.
Right.
And second, he just was like, we don't need to take this to appeal. Let's just make it go away at this point. Because so it doesn't happen often, but a really hostile judge can be in your favor sometimes.
Unfortunately for us in the state of Maryland, not in the district court, because we have this very interesting thing from the district court, which is you get a bench trial, which is the trial in front of the judge, versus the circuit court where you get the right to a jury trial. Is from the bench trial in district court, you get an appeal de novo. So everything the judge does in district court, if you appeal it, doesn't matter. Nothing the judge ruled on matters. So they can be as hostile as they want to be in the district court, because the circuit court judge is not reviewing the case for the record. You get a brand new trial in front of a jury, and none of the judge's evidentiary rulings matter. The only thing that matters is if your client testified in the district court and then they testify in the circuit court, the state can impeach them with their district court testimony. But otherwise, your judge could have thrown a book literally at your client, called them a piece of crap, said that they were a monster. And sure, you can be the idiot that complains to judicial disabilities and, they find out it was you and now you're, blackballed. You can be that. Or you just appeal de novo and hope for a better result with the circuit court judge who will be on the record in a jury trial. So, you'll get comments like that in the district court. Things like, I'm not going to teach you how to practice law, or if I don't hear from your client, I don't know what I'm going to do, which is completely unconstitutional because your client has the right to remain silent. Wild West District Court. Let's keep it going. Yeah. Let me mute myself.
Would it be fair to say that it was difficult to see if anyone else was struck?
From the position I was in, I seen a tire going in front of me. So no, I did not see directly anywhere besides the tire going in front of my face.
So it would be fair to say that you didn't see anyone get struck besides yourself?
it would be kind of difficult to see beyond that.
No further questions.
Can I redirect?
Can I just clarify, Ms. Grabo? The last time you saw your daughter before you got struck, where was she?
Objection. Irrelevant.
Overruled.
What do you mean relevant?
She came over to me to get more candy to pass out, and she was walking off to the sidewalk to hand out more candy.
Sidewalk on which side of the Burris float?
Objection, hearsay.
Overruled.
That would be to the driver's side so to the left.
Okay. And then you got struck. And
See, I it's almost maddening. I'm so sorry, but it's like you need a lawyer, man. That's not hearsay. This thing happened to you is not hearsay.
Well, so I actually want to tell the chat this. What's really funny about this in the entire afternoon, you want to learn a little tip about body behavior language. Every single witness during cross-examination swivels their chair. It's a coping mechanism to deal with anxiety and heightened stress. It's an active movement that is a calming gesture to them. So when you see every single witness, I want you to watch them during cross-examination. Every single one will swivel their chair.
Well, I didn't know that. You learn something new every day. You learn something
I just
new.
attention deficit, so I swivel my chair just because it's a chair.
Yeah, I mean, I'm a
if I had you
mover.
on the stand, I'd be screwed. And I think Natalie would too. We'd be doomed. Oh, look who's back.
Let's go.
Did you get a cocktail?
No.
All right,
Bert,
we're watching
let's go.
Swivel Chair.
We're watching the swivel chair. Let's go.
and where's the next place that you saw Adelia?
I seen Adelia.
Overruled.
She didn't see anything.
It's not hearsay, Mr. Brooks.
That's the definition of hearsay.
Mr. Brooks, the objection is noted.
She can't tell you what the
Overruled.
definition of hearsay is.
I direct your attention to section 90801, sir. You may answer the question.
After I got up, I found my daughter in the middle of the road. She was no longer by the sidewalk.
Where was she in relation to the Burris, the truck that was pulling the float?
Objection, hearsay.
Overruled.
No grounds.
Direct your
On
attention to
grounds that it's
90801,
dumb.
sir.
On the ground that that's not hearsay, and on the ground that it's just really bad strategy to highlight where she's like, yeah, my baby was in the road with me, and then she's over there after this guy came barreling through us. This is not the testimony you want to highlight with a bunch of bad objections. No?
I'm just like, objection, this, he's like, on what grounds? I'm like, that it's not even close to correct.
It's like with every false objection, it's just allowing the testimony to marinate with the jury that much longer. And that's what it's just, you're allowing the jury to think about her testimony more and more and more with each. Because I would imagine, I'm not a criminal defense attorney, but I would imagine you want to get this cross quick and done quickly to move everything forward. You don't want to have undue necessary time going on.
Well,
yeah.
I mean, critically, this guy isn't achieving anything in terms of, like, this witness isn't telling us anything we didn't already know. It's just, kid was injured. This is really sad. Like, the details about the candy and so forth are heartbreaking. And so this isn't like harming the aspects of, trying to get through or of his defense in terms of like, did this happen? Was it him? Those kinds of questions. Mm-hmm. So lingering this out is really terrible. You want to move past this and get to places
Yes.
where you can maybe get some points in.
Yes. Yes. Absolutely. Absolutely. All right, let me keep it going. I couldn't agree more. He's just highlighting the worst parts of these people's testimonies with these stupid objections.
It's not hearsay. Go ahead, you may answer.
She was towards the driver's side, the front end of the vehicle. So she was more towards the front of the vehicle.
You testified that after you were struck, the noise in the area increased. It got louder. You
Yes.
saying that? And so, as a result of that increase in noise, you weren't listening for a horn?
No,
Okay. What about before you got struck? Did you hear the sound of a horn?
I did not.
Hearsay.
It's not hearsay, overruled.
I did not
Yep.
hear a horn.
The horn is communicative conduct.
Fine, but if there is an objection, let me rule on it first.
The horn is an out-of-court statement being offered for the truth.
No, the fuck it's not.
All right, you may step
Truth
down.
of beep,
you.
beep.
Oh my god.
For the truth of the blaring noise.
Also, you yourself asked about the horn earlier. So you can't object to hearsay because it can't be both admissible and inadmissible at the same time.
You open the door. That's a great
You may
point.
call your next
Also
witness.
that.
The state would call Jeffrey Rogers.
Also, it's not hearsay.
You said Rogers. Thank you.
So just take your pick.
This is just, to me, you guys, please don't take my laughter as like I think it's funny. It's just, to me, it is gallows humor. Like, I cannot help it when things become so horrific that you just cannot help but to be like, good Lord, you know? So I would like, but with the panel's permission, you know, by consensus, to skip to his cross-examination of these witnesses, because of the next witness, and I think we'll call it at the cross-examination of this next witness. But I don't know what you guys think.
That's fine.
Okay.
Yeah.
Are we good?
Yep.
Anybody want to hear the horrific detail?
Nope.
That's
Nope.
exactly. I just don't need that. Oh, this guy was actually a very good witness. A very, very good witness. Okay, for the state.
And super composed.
Oh.
The prep that they gave him, and you can see, like, he's doing the shoulders forward, like he's grasping his hands together in the front, like everything about him is just trying to remain composed.
Rob with the body language here. I don't really put a lot of stock into body language, but the things you're saying, I'm like, pretty some observations I've made myself, so I can actually see that. I can see that. So they go through a lot with like where people are, have them circle themselves and their children and all types of stuff like that. As everyone was saying, these are very prepared witnesses with a extremely unprepared defendant. Okay, give me one moment, please. Okay, they're gonna take a little break, and and then he's gonna.
Is this the hearsay instruction? Okay.
Here we go.
Just from way of my own education, was there a motive established in this at some point? I honestly don't remember.
They established a bit of a timeline where immediately before this, so he's been convicted of domestic violence and charged with domestic violence related offenses before. And he's been with this woman since she was 15 years old and he was like 23 or 24, something like that. They have a child together. She's 30 now. He's like 41, something like that. She moves to Waukesha County because of him, because they both moved there with their child. And she's living in a homeless shelter, a women's shelter. They meet up at a park and she with a friend of hers, and she alleges that he assaulted her. And there was another woman there with her and drove his car at her and then like punched her in the face, assaulted her. And there's pictures of her injuries, and then was angry when the friend intervened and was like, leave my friend alone. Stop beating up on my friend, and drives away. And they're saying immediately after drives into the parade. That's not a reason to me. That doesn't make any sense to me whatsoever, other than I was angry. I just I don't understand it, but that's the sequence of events that the state has established or attempted to establish to the jury thus far. We'll see what they believe, but I'm saying these things because I have to. I'm a defense attorney, guys. But seriously, like, I don't understand.
I mean, it's not legally relevant. I was just curious if he had sort of anything that made any sense, because it's like, what makes something scarier? A defendant whose motives you understand, or someone who's you don't?
True.
And like, it's like,
Yeah.
at least if it's understandable on some level, but the really scary ones is where it doesn't make any sense.
That's right. I mean, even like,
Yeah.
okay. This is gonna sound super weird, but but this has been a stream of just weirdness. So why the hell not? Serial killers make more
shit.
sense.
Sorry. We went there.
Yeah, serial killers make more sense to me than spree killers, like, or like mass killers, right? Like, okay, so someone that just like breaks and drives into a parade, or goes out and shoots up a school, or goes out and starts stabbing a bunch of people. Okay, so a serial killer, I think like, oh, you have some type of sickness and you're fixated and you're just completely nuts and you just do this thing over and over again because you're just like completely out of your mind. For some reason, that is something that squares more to my understanding of like extreme psychosis than I just woke up one day and decided to drive into a parade. I just can't comprehend it. I can't understand it. I can't understand school shooters. I don't get it at all.
Yeah.
I would like to
probably
agree. I
okay.
know that's like a weird like that's not logic. It's not logic. It's a feeling thing. Like, it's just I feel like I cannot understand someone doing this. I can comprehend someone like, oh, when he was little, he killed animals, and then he was a bedwetter. There's like a pathology for that, and then he couldn't make any friends, he couldn't get any girlfriends, and he was overly attached to his mother, and then he killed a person, and then he killed another person, then he killed another person. That's like something I understand that there's a pathology for. This, I don't understand the pathology, but why would you do this? I don't understand. I know I'm probably not making any sense, but I'm probably just out here floating on my own in my own world.
No, you're not, because the chat is like 100% basically agreeing with you here. Like,
really? I wasn't looking.
You're solid. You've got the chat's backing on this one. The entire chat, I think. Yeah.
Well, thank you, chat. You don't have to. You could be like, she's nuts. But I don't get this. So you had an argument with your girlfriend. So what? You know what I'm saying? You're mad because.
But you didn't kill the girlfriend. You didn't kill the friend.
Yeah.
You decided to take it out on completely unrelated people.
Yes, exactly.
This is it. What are these 6 people? I don't want you to kill your girlfriend, obviously. Please don't do that. But why did you go and run through this parade? What is the pathology? I don't understand. Why does someone else have to pay for your anger? Says Dealey Moo.
Yeah.
I would like
because he's not going to.
Well, he will now.
Yeah, I suppose there is that.
Well, and to the chat, I remember this witness, not at the beginning of his testimony, but towards the end of the cross, like slight trigger warning, because Brooks asked some questions that has to deal with like the car and people, and just be aware it's not pretty.
Yeah.
I dislike this guy so much.
Yeah.
I think, I don't know. I just feel like he's making us all lose our minds, because he's making me lose my mind. Let me just put it that way. Okay, let's go.
Kill the 8th Amendment for him.
I apologize to the witnesses. a little emotional right now for me, so I apologize to the court as well for
Emotional for you?
Oh God, yeah.
Okay.
Oh,
He doesn't understand optics. Oh.
It's the least of his problems.
Can you recall what time you arrived at the parade that evening?
I don't remember exactly.
Do you recall how long you intended to stay?
Through the parade till it was done.
like
You testified earlier to seeing some of the video footage that was played. Would that be fair to say?
Yes, that's fair to say.
Do you recall how many times before today you saw the video footage?
I believe I saw one of the videos once.
And you don't recall seeing any of the other videos?
Maybe clips we were bouncing around.
Do you recall by whom you were showing the videos?
The folks at the prosecution table.
That referring to the 3 prosecutors sitting there right now?
Yes.
All 3?
Yes.
Wake me up if you ask a question I actually care about.
Oh, he gets there.
You stated in testimony earlier that you did not see the vehicle strike the children that were in front of you. Would that be fair to say?
I said sitting here today, I don't remember that.
You said something to that effect. Would that be fair to say?
You'd have to be more clear.
You said something to that effect of what you just said.
Yes, he just said said it. What are you talking about?
Today that you do not recall seeing anyone struck ahead of you.
That's correct.
But then you also stated that you did see who was struck ahead of you.
Is that a question?
Yeah.
Would that be fair to say?
In relation to what?
In relation to someone being struck in front of you.
When I was there, or the video? What are you talking about?
At any time. When you was there.
When I wrote my statement, I wrote what I remembered at that time.
So would it be fair to say that as you sit here today that anything about your statement may have changed?
Nothing has changed.
So your testimony here today would be accurate to what you reported?
Everything I said has been accurate.
You don't start with the impeachment.
Yeah.
What are you going to do? Find some minor inaccuracy to say, well, did you change your story about this? I mean,
Kurt, you are actually predicting the future.
Yeah.
I mean,
My thing though is, go ahead. Go ahead.
It seems like that is what he's going to do, because I can't see that he's got a sort of any particular angle to this. But
you know, it's actually pretty suspicious if someone tells the exact same story 2 times.
Yeah, correct.
After a traumatic event, people are going to be inaccurate.
Yep.
And memory is fallible.
Yep.
Now, that doesn't, again, I'm a defense attorney. I'll tell you all day. I'm going to impeach people, but you have to use discernment and be wise in what you're going to impeach people about.
You said it would happen at 2:45 when now you're seeing it happen at 2:30. Which is it?
Exactly.
Yeah.
Like, tell me that every attorney on this panel wouldn't have passed on this witness. Like,
Absolutely.
Pass.
Yeah. I would have
Pass.
nothing to ask this question, this witness.
unless you've got a really good impeachment, you just let this go.
Right. It would be okay for the people, not this witness aside, for the people that said, I saw the car speeding past and I recognize that person to be the guy that's sitting here in court today.
Yeah. Good.
Right? Okay. then you find out that that person wears glasses and wasn't wearing glasses that day.
There you
Or
go.
you find out that person had a major knock on the head, so they can't really remember
Yeah.
what they saw. You
Yep.
ask that question and then you
Yep.
leave them alone and you move on. But that's not the type of impeachment he has. The type of impeachment he has is, was that person sitting in a gurney or were they laying on the floor in the hospital? You said before they were laying on the floor, but now you're saying they were sitting in a gurney. Whether they did that or not doesn't help you, number one. Number two, doesn't matter to the elements of whether or not you mowed people over with
No
your
one
car.
cares.
No one
Yep.
cares. And
Yeah.
it amplifies the bad facts, which is that people were mowed over by a car and were in the hospital, right?
God, so bad.
It's tough.
If you have a comfort unicorn like or a squishy like near you, you're gonna need it for this.
You know what? Let me get my blankie that I always have in here because I
That's-
definitely
yeah.
need it.
You're gonna need it.
Okay. All right, let's go. I got my blankie. I've got my grounds. I've got my objection. Okay. I'm ready to go. Let's go.
I've got my comfort scotch.
Do you recall saying in your interview with the DIC that your 11-year-old son and 9-year-old daughter suffered minor injuries in the event?
I remember saying they were injured.
Do you recall saying that the injuries were minor?
No.
Not direct the witness to the statement?
Do you have a copy of that?
Summary.
Yes, right here.
Is it his statement or summary?
Summary.
It's not his statement. It is a statement from DCI, an agent from DCI, in which the DCI agent spoke with Mr. Rogers and wrote down what he believed was said to him. It was not signed by Mr. Rogers. It was not reviewed by Mr. Rogers.
Yep.
So there's two things at play here for me, and then you guys springboard, please. Number one, she's right. You know, when you can't really impeach somebody with a statement that's not their own. So a lot of the times we run into issues when trying to impeach somebody where the officer wrote down what the person said. The person did not write it themselves. However, this is not, in my opinion, a proper objection, but this objection is going to get sustained, and he doesn't have the right way to fight it. You
I
ask
can
this
overcome
person.
it.
The thing is,
Go ahead.
this is totally something you can work around. Like this, there's a way to do this.
Yes.
What you do is you say, I would like to show you a summary. Like before you start your impeachment at all, you say, I would like to show you a summary of, that this officer made, of the statements you made to this officer. And they say, okay, thank you. And you say, is this correct? Is this accurate? Yes. No, I want you to read this carefully. Please go over this. This is important. Is this accurate? Is the officer correct in summarizing this? Yes, it is. So there's nothing in there that you want to change. No, it's good. Now you can drop the hammer. But you can't start with the hammer and then try to backtrack.
Or even better, you retrofit them both with knives. And the way you do that is you basically say, didn't the officer, you recognize this? This is a statement the officer took. Yes, this is a statement. Well, do you completely agree with everything in that statement? Well, yes, I do. And then you say, well, is the officer wrong or are you wrong? And you basically put the witness against the officer, and you basically make the jury doubt whose version. I get, like, there are ways to go at this. The way that you don't go at this is you just don't. You don't do anything he's doing.
The technical term for what you guys are talking about is laying the foundation for the impeachment, right?
Yeah.
And because he didn't lay the foundation for the impeachment, he's open to this objection. But I'm still gonna stick fast to my opinion that this objection is still improper because you can ask him about that, right? You can ask him about that and ask him about how you didn't write this, did you? You didn't sign this, did you? Or he could even say to the judge, Your Honor, I would ask for us to approach and for them to lay out to you why they think that my questioning is improper. But instead, what she's doing is testifying for this guy, because this guy hasn't said, I didn't sign this. I didn't look at this statement. I didn't. So you see what she's doing? She's actually testifying for what he will say. And what that's doing is tainting the witness. So that's not appropriate, in my opinion. But Mr. Brooks doesn't know to object to what the prosecutor is doing right now. And so she'll get away with it. It's fine. She's allowed to do it, as long you can do anything as long as no one's going to object to it.
Sure.
And this is why you need counsel. All right, let me shut up.
Therefore, I would object to this being characterized as this witness's statement.
Grounds.
If he would like to call,
She just told you the grounds in detail.
Right, I'm going to sustain the objection as to the form of the question. Rephrase, if you're able or desire.
He's not.
Do you recall stating to whomever interviewed you from the DCI that the injuries were minor?
No.
Any reason why they would report that you said that?
I don't know. You'd have to ask them.
Speculation.
Any reason why they would believe that that's what you said?
Objection.
Reported. Grounds.
Relevance.
Grounds.
He is so fast.
Sustained.
He is so fast. It is amazing. Like if Olympic sprinters had this reaction time when the gun went off and people were going and sprinting, they'd all be Usain Bolt. This guy is so fast out of the blocks with the grounds.
Grounds. But she's like, relevance? Hearsay? Whatever the ground she was saying, I don't remember now. She's saying the grounds, and as she's saying the grounds, he's like, grounds. The grounds. It's driving me insane. I still
grounds. Grounds. Do you know what it is? It's not grounds. It's obgrounds. It's obgrounds. That's what it is. It's obgrounds because they never get the ejection out of it.
Grounds.
I threw it on the ground. The whole trial too. I will be part of the system.
Old memes.
He's channeling Lonely Island.
Yeah.
Do you remember giving a prepared statement at 10:45 a.m. on 11/22 of 2021?
I do.
Do you recall the gist of what you prepared?
Just.
Can you be more specific?
Well trained.
Specifically, that you heard commotion, turned around to see a stroller or something fall over about a block and a half behind us.
Yes.
You recall making that statement?
I do.
About how many people would you estimate was at the parade that day?
I would guess the thousands.
And you were able to see
relevance,
something fall over from a block and a half away amidst thousands of people.
Yeah.
Yes.
It captured my attention.
It's a good question, actually.
When the car started mowing everything down,
You
yes,
don't
I was
recall
paying
what that
attention to the things
was that
falling
you
down.
saw?
No.
Any reason as to why you would name what you saw fall if you don't recall it?
I described it.
So you did see something fall.
Objection asked and answered.
Wow.
Asked and answered. Sustained.
It is. I
Not
don't
really.
know.
Recall what the item
No.
was.
Objection.
Grounds.
Bad ruling.
Asked and answered.
Grounds.
Yeah.
Sustained.
Bad ruling.
We have a debate.
ruling.
Was that question asked and answered? Well, let's listen. Never fight about what I want to hear. I'm sorry. I just
No,
wanna
it
hear it.
wasn't. I have the right to ask the question. You have the responsibility to answer exactly the question I've asked you. And if you don't answer the question I asked you, I get to ask the exact same
You get-
question, the exact
That's
same wording
right.
again until you
That's
do.
right.
Now,
right.
I'm not defending this at all. This is calling balls and strikes. This is one the judge gets wrong. The judge gets 99.9 or whatever percentage you want to think, right? But this is one she got wrong.
She
And
gets them
sometimes
wrong. Go ahead.
Sometimes in cross-examination, you need to re-ask a question, and that's proper in the sense of like, so, you swung first. No, I didn't. Okay, let me show you this video. So you swung first, after you've shown the video of that happening. That's a proper, re-ask of the question, because sometimes that's just how that goes. This is kind of frustrating.
Grounds.
No grounds.
Calls for speculation on the part of the witness. Sustained.
I'm gonna start chugging wine bottles pretty soon.
What if any grounds? What if any
Don't,
grounds?
Natalie, if you throw what if any in there, I will throw something.
Do you remember
No.
giving a prepared statement at 10:45 a.m. on 11/22 of 2021?
Maybe he should throw out a what if any. Just bring it to our hearts. Write him a memo.
Do you recall
Ask what
the
if any
gist
if
of
it
what
comes
you
all every
prepared?
possible objection.
Can you be more specific?
Training.
Specifically, that you heard commotion, turned around to see a stroller or something fall over about a block and a half behind us.
Yes.
You recall making that statement?
I do.
About how many people would you estimate was at the parade that day?
I would guess the thousands.
Yep.
I will
plurality.
say that I'm actually kind of glad I didn't go into criminal law.
Something fall over from a block.
Part of me
and a
was
half
interested.
away.
I would love to
an
be
answer.
more
It's
in the
thousands of people.
courtroom, but
Yes.
I'm definitely glad I didn't do criminal law, to be honest.
That's an unfortunate
And you
pause.
don't recall what that was that you saw?
No.
Any reason as to why you would name what you saw fall if you don't recall it?
I described it.
Yep.
So you did see something fall.
He already said they did.
Asked and answered. Sustained.
Jesus Christ. Sorry. All right. I'm going to shut up. I'm going
Do
to
you
shut up.
recall what the item was?
No, you're not.
Grounds.
Asked and answered.
Grounds.
Sustained.
Natalie literally went and got popcorn. Natalie literally went and got freaking popcorn. Look at her up there. Look how happy she is right now.
I'm glad someone's happy.
Yeah. And now
Do
she
you
is
recall
joking on
about what
popcorn.
time you heard that shots were fired?
After watching the video, it's about 3 minutes, 2-3 minutes after the red SUV drove by us.
Do you recall the day of the incident? Not the video.
I remember it was after the vehicle drove by us.
Did you hear the shots?
No,
Do you remember who that was reported by?
I don't.
Do we want to do an over under for how long the jury takes? Are we taking bets yet?
Not yet.
Okay.
I looked for all of my children again and made the decision to take 2 of them into the antique store.
All right, everyone wait here. This is a little trigger warning.
About how long did it take you to look for everybody before you went into the antique store?
Before we launch into the trigger warning, this would be a good spot for no further questions, Your Honor.
Yep. Really good spot to stop talking.
You know?
Artie has been way too quiet.
Way too quiet.
I'm just sitting back and listening, marinating. like what's and kind of dreading what's about to happen, because again, throughout the day I had my day job, but I had the trial like in my headphones, and so I'm like kind of half paying attention, half listening. So I was aware of this witness, but I didn't hear any of the cross examination. So I'm wondering.
Oh, so already has like a half idea of what's about to happen.
No, I actually don't have any idea about
Oh,
what's about to
it's
happen.
not okay.
I am so terrified. Let's plunge forward.
Before or after the shots fired comment?
After the shots fired.
I think I did another lap around the car and then around our Blazers truck and then grabbed my kids and left.
Were you able to retrieve everyone at that time?
No.
You recall who was missing?
Riley was missing.
Did you leave the antique shop anytime after you had gathered your loved ones into the antique shop?
Yes.
About how long before you left the antique shop?
Thank you, Edwin, for
I
the
don't remember.
$9.99 super chat.
Do you remember what you did when you left the antique shop?
I remember at some point seeing Jackson again on the ground.
Did you continue looking for the loved one that you missed before you gathered the other ones into the antique shop?
To the best of my recollection.
You don't recall for sure?
It was pretty chaotic. I was looking constantly for my missing daughter.
Did you end up finding her?
I did not find her, no.
And who is Ben White?
He was another coach with the Blazers and a friend.
Was he with you in the antique shop?
No.
Why do I care about the antique shop?
So at some point you got separated. Would that be fair to say?
Separated from who?
Separated from Ben.
We were all separated as soon as the car drove by.
Any idea where he may have gone at that time?
No.
You remember talking to him after you had gathered everybody in the antique shop?
I remember at some point he reached out. I don't remember if it was text or phone call. Yes.
Did he say if he was injured in any way?
I don't remember.
Were you injured in any way?
No physical injuries.
Was it pretty windy that day, from your recollection?
From what I remember, there was a pretty good breeze, yes.
Pretty cold?
It was cool.
Pretty loud?
Normal parade sounds.
Would that be characterized as loud?
I guess it depends that would be subjective to the person there.
Would you say it was loud?
You don't have to win every point.
Not overly loud.
Sometimes it can be worth writing the witness on this kind
So
of
you
thing.
yourself were able to hear pretty good over a parade with thousands of people?
You're pretty well.
I would say so, yes.
You had one of your daughters, Maya, with you that day. Would that be fair to say?
That's fair to say.
Was she injured in the event?
I threw her to the ground to get her out of the way, so she had some scrapes.
And would that result from you throwing her to the ground?
I don't know.
Oh,
Did she say that she had been injured in any way?
No.
Do you recall if anyone else besides your children who were injured?
I remember lots of people who were injured.
Do you recall?
I just answered that.
Specifically?
Yeah.
You remember who besides your children?
Oh,
You know,
name them.
list all of the names that were injured
Just rough estimate. That you recall.
that I recall.
Name every child that was
10 to
injured.
15
Oh,
people
God.
that I saw.
That you actually observed.
Yes.
That wasn't the same
Did
question.
you render any assistance to any of those people?
No.
Oh.
Oh,
Any
What?
reason why not?
Yes.
What? What?
No.
What?
Nope. Natalie, you missed the next one. Like, I promise you, play through the next
This
question.
is not it?
Play through the next
Did you
question.
render assistance to oh
Play the next question.
self-control?
isn't this all your fault then?
Wait.
My daughter was missing.
So it'd be fair to say at that moment your concern was your daughter that you didn't retrieve to go into the antique shop.
My concern was for everyone that was just struck by the vehicle.
Including your daughter that was missing, right?
I was concerned about her missing, yes.
One would imagine. Went to this, right? Please.
Did you file any reports?
Oh my God.
Other than
Yep. He literally did the whole, why did you not give assistance?
Because you were too busy looking for your own daughter who was missing. Selfish. That's how it came across to me. And then right back to the sovereign citizen bullshit of did you file a claim?
Have you seen the written complaint in this? Have you read the complaint in this? Are you a plaintiff?
How dare you, sir, be concerned about your own child?
Why didn't you render aid? Why weren't, just like he asked another witness, why weren't the nurses helping the people on the ground?
Did you ever find your
They were
daughter?
helping other people. I'm just going to take a punt.
That's exactly what it was. There were too many people to help, so they had to triage.
Can you list and identify the victims? Like every question.
Because you were too busy looking for your own daughter.
Yes.
Not that there's any answer to that would help, because of course he has no affirmative duty anyway. So even if he pointed at them and was laughing, it still wouldn't matter.
Oh my God. I'm so disgusted right now.
Yes.
Uh-huh.
And this is the witness that he doesn't like go overboard with.
Wait, this is the good one? Like this is his good?
Yeah.
This is not going overboard?
No. Next, the other dad.
We're at 2 hours and 30 minutes. We
I
can
know.
skip
We
to
don't.
the other dad. But we're at 2 hours and 30 minutes, so I'm
You're
giving
hurting
you
my
guys a
soul at this
warning.
point.
Why are we echoing? Someone, hang on, I'm
Is
gonna
it
mute
me?
myself.
Couch.
Are we gonna call it? Are we gonna call it, or are we going to see how he was bad with the other dad?
I'm probably going to continue on, even if we call it here, just to see the rest of the
we can watch more
highlights of the events.
I gotta see what happens here.
Okay.
Continue with this guy or skip to the other dead?
Skip to the other guy, and I'm gonna get a glass of wine and hope that somehow it makes it all better.
Okay. It could be me that's causing everybody to echo because we all know that my mic ain't shit. So bear with me. I will mute
Testing.
myself and unmute, and hopefully it'll do something.
Well, let me see. Testing. Is that any echo there? I don't hear an echo.
I don't hear an echo either,
Nope.
but I
We're
never
good.
heard one.
There's probably a lag somewhere.
No, in all seriousness, I am so glad you said something about the unicorn, because holding this blanket has helped quite a bit. This has been quite upsetting to listen to. And
Yeah,
I've
and look at
heard
look at the
some-
dad. Look at this dad right here. If there was a personification of staring daggers,
yeah. Some people have said that they're glad they're not there. They're glad they don't have certain weapons. They're glad they're not around him. This is horrific. He has the right to represent himself, but this is why representing yourself is such a bad idea. My God.
my screen at my office is very glad that I didn't have a hard object to throw at it.
Oh, my Lord. Okay. Oh, I'm having a hard time. All right, we're skipping to the next dad. Anyone remember what color shirt he was? Was it a burgundy shirt? Anybody remember what color shirt he was
I thought it
wearing?
was a black
White
shirt,
shirt.
wasn't it? Or was
Black
it white
shirt or white shirt? It was one of it was a complete neutral color. Him. Who looks like the MMA fighter who's going to come over the bench and
beat his
do
ass.
physical. Oh, and there's
Yeah.
parts of this testimony where you really think he might.
So we're going to go to cross-examination, as we've been doing with, this is now the third witness that we've highlighted, simply because this stream is focusing on the sovereign citizen foolishness, the poor questioning, and just the general self-sabotage of representing yourself while being a sovereign citizen. So,
And trying to maintain our own mental health during the process. That's another
Absolutely.
lesson that you guys should see. Comfort creatures and comfort blankets are wonderful things.
I mean,
And comfort
we're
wine.
already embracing self-medication at this point, but you
Yeah.
know, it is what it is.
We're there.
I'm trying my best to reduce my drinking. I'm not really succeeding.
This is the
at
wrong
all
stream
times.
for that.
Yeah, but this is definitely the substitute at this moment. I want to emotionally eat at this point. Okay. Whew.
Emotionally eating does sound pretty good right about now.
Mhm. Roller coaster, brace yourselves.
Did you see the vehicle approaching?
Oh, let me know when you need it.
Serenity now.
Oh, hang on. I need
Serenity
to pause this. Pause. Context that's given in direct examination of this guy. He testifies during direct examination, and then the initial part across. Brooks asks him when he saw that, if he's ever seen this video. And the first answer is he has never seen this video before. Before taking the stand, this father has never seen the video before. And the second that he asked that question and I see that answer, I'm going, this is going to go absolutely terrible. The dad is now watching the video for the second time, being asked to be played by Mr. Brooks, and he's going to start pinpointing and pausing. So this is a little bit of a yes. And I'm trying to warn the chat to give context for what's happening. He has not seen this video.
Wow.
This has been such a calamity, such a series of errors. This is another terrible, terrible error. Going through bit by bit with someone, he's the dad of one of the injured children.
Was he there at the time?
Yeah. It
Yep.
sounds like.
Okay, just trying to
Oh,
make
my
sure
Lord.
reference. Okay, fair.
Okay, we're ready. Thanks, Rob. Thanks for the context. Artie, you okay? You good?
Let's go for it. Let's rip off the band-aid.
Uncle? Check it
Look, I mean, good is relative, but let's go.
We can do it. Okay.
Do you see yourself? It's been paused at 18 seconds. Do you see yourself in this still shot?
Yes.
Can you circle where you are?
This is the direct still.
All right, so that's the first time. That is the first time he has seen this
I'm sorry,
entire
it's
video.
a touch screen. I guess I need to add.
Would it be fair to say that you're walking pretty good as of now?
Objection.
Grounds. Just walk to the
Sustained.
bench.
Not relevant.
It's not relevant. I only ran over you a little bit.
Did you
Look at his
also
face.
remember stating that you don't remember much from the event?
I do not remember saying that.
And I guess it would be the summary of the report of the statement that you gave to the officer, which I have right here. It says that you stated that you don't remember much from the event, but made it clear that your primary concern was needing to know where your children were after being struck. Would that be fair to say?
Yes.
Look at his arms. Why are you doing this to this man? He will.
You should be allowed to at this point, as far as I'm concerned.
I don't really just.
Allowed or encouraged?
I don't know.
Celebrated,
extolled. What you did after being struck?
I could not move. I was on the ground.
Like I have to.
Do you recall how long before
split myself between my lawyer side and my human, my human side.
There's human in there, and we're definitely, yeah.
Actually, say that again, Artie, because I actually wanted to say something about that, and your audio is like a little low, so it was hard for me to
sorry.
hear.
I was just saying, like, when we watch things like this, you have to keep yourself in the mind of an attorney, and you want to uphold those kinds of, the principles and the understandings of his rights and his Sixth Amendment rights to face, the witnesses against him. And so you try to keep yourself there, but then there's also the human side who would like nothing more than this guy to run over the defendant's table and knock him senseless.
I think you're forgetting the U.S. Supreme Court case of Get versus Fucked, where this guy doesn't have rights.
Oh my God, Kurt! Oh, Kurt, that
From the 3-point line. Damn.
Dude. Oh my God, that was too good.
I'm struggling. Okay, I'm struggling with this case because just like I've been watching some of the Cruz case, the school shooter case, and I'm really struggling with this case because he has the right to cross-examine all of these witnesses.
Mm-hmm.
But because he doesn't have the extra buffer of an attorney doing it for him, it's like adding insult to injury.
Yes.
Because the person who allegedly committed the offense is now probing you about. So remember that time I hit you with my truck?
Yeah.
How did that feel? And after I hit you with my truck, why didn't you pick up your daughter? Why did you only help her and not all the other people? And it's very like awful. But I would never advocate for any attorney not to ask the questions that need to be asked and to give a vigorous cross-examination, no matter who the witnesses are, because you have to be a zealous advocate. But it's weird when it's the defendant himself. And also, a lot of the questions are not probative of anything. So they're insulting, they're painful to listen to, they're irrelevant. And so go ahead.
Yeah.
In Canada, there's actually a rule for that. You can apply for essentially you're self-representing, but they can apply to require that a lawyer conduct the cross-examination.
Oh.
And so I've done this where, and it's literally like this guy's running his own trial. You walk in, and when it's the complainant, especially with like kids or SA cases where it's like super tense, but I mean, this one wouldn't be a bad place for it. I, as the lawyer, come in because I'm going to ask only reasonable questions, right? And I'm not going to, I'm not going to try to batter the witness or anything like that. It's just like, let's get in, get the evidence we need, get out, and that's it. But yeah, I guess they don't have anything like that for this.
Well,
no, I mean, he could go ahead. So someone's going to say something.
I was going to say, I have two observations, one that's like real and one that's funny. Like the real one is like, I 100% agree with Artie. What you guys are actually seeing with all of our reactions is like you're seeing like the devil and the angel on both of our shoulders, like fighting with each other. And it's like there's a cringe element that you are seeing all of us kind of display. That is this fight that we're having internally. And then the second one, the funny part was, I think I have a runner up to the Get versus Dactar in the comments said, I thought it was F around versus find out.
Yeah.
Oh, that's
I saw
cute.
that too. It was great.
I've been using that as a line. I'm trying to get my t-shirt company to put that on their shirt, but
I think
they
Kurt
don't
just
like it.
patented the get versus.
Yeah,
And the delivery, the
So
delivery was so good. It took me down. It took me
Someone
down.
clip that. Someone clip that and send it to me, please, please, please.
Yeah.
Oh, and me too, because you guys know I'm the worst at clipping things. So please, someone clip that and someone get that to us because that's going on the Twitters. Absolutely.
The F around is like the citation of that one works better in Canada because it's typically said as, party A and party B. So it's the case of F around and find out.
Oh, that's good.
Yeah, I like it.
Well, in all respects, Mr. Brooks is fucking around and finding out, and he is getting effed.
He's gonna learn.
He's finding out.
He's finding out the consequences of his actions. Sadly.
Yep. Mm-hmm.
Ugh.
Yep.
Yes, 2 people.
And where did they take you?
Into the joke shop.
And from there, did you receive any medical attention?
Yes.
Do you recall where that was?
Memorial Hospital.
You recall who took you to Memorial Hospital?
A squad car.
You remember the officer's name?
No.
Do you recall what date you made the report to the officer? Or the date that you were interviewed, rather?
Which time?
So there was more than one time?
Yes.
Oh, he hates his ass.
Yeah.
Oh yeah.
Do you recall making or giving an interview rather on the 24th of November of 2021?
Yes.
And by the way, that is an aggressive posture. Like
you
witnesses
recall
don't
what
usually
date
do
the
that.
other
Oh yeah.
report was taken?
Just wants to kill him.
The night of.
The sheriff at this point is here for this guy's benefit.
Yeah,
pretty much.
Yeah, you don't need to be an FBI, expert to
Profiler, yeah.
just to get a sense of the body language here.
I think the bailiff and I are just going to leave the courtroom here for a minute and whatever happens. And oh well, he's dead. That's unfortunate. Moving on.
Oh, so good. Okay. Ooh, okay. Composure.
Serenity now?
Yeah.
Do you remember my home that night?
An FBI agent.
You remember his name? Was he part of the sovereign FBI?
Did you file a claim against the corporation?
Oh no.
Did you see a flag?
After being
Did it have a
struck,
gold
you
fringe?
testified that you saw the vehicle kind of go up on the curb. Would that be fair to say?
Can you ask that again?
What did you see the vehicle do after it struck you?
After he struck me, it continued.
What did you see it do?
Do you really want to know that?
Drove off.
No.
Did you see it strike anyone at that point?
No.
You were on the ground.
Were you able to get a look at the driver in any way?
You were on the ground.
A license plate number in any way?
No.
Hit by a car.
I mean,
Questions I would ask.
Question.
Probably the only questions I would ask of this guy. Yeah.
Yeah, exactly.
License plate number?
Yeah, but you ask it before he's on the ground.
You justified for the jury earlier that you heard screams from behind you before you were struck. Would that be fair to say?
Oh God.
Yes.
This is why I prefer appellate law right here.
Point? Did you turn to see if anything was approaching at that point, rather?
Yes.
About how far was the vehicle away from you at that time that you observed it?
20 yards.
You were able to make that assumption how?
Not an assumption, it's an estimate, you idiots.
You know, we go off yards a lot.
That makes sense.
Oh, there you go.
I mean, I shoot, and I would totally be like, "Yep, range estimation is part of that."
Would it be fair to say that that's relatively close?
Yes.
Close enough for you to see into the vehicle?
I did not see into the vehicle.
So it would be fair to say that at no time during the incident, you saw the driver.
I did not see
No,
the
I did not.
vehicle.
This should be his defense. This
That's the
should
thing.
be his defense.
These should be like the handful of questions
Did you
you
see
should
the
have
driver?
asked.
No,
And
great.
call it a day.
Where you said that your children were not injured in the incident. Would that be fair to say?
Not physically.
Where else?
Not physically.
The witness answered it. His answer may stand. So the objection is overruled.
And when you were treated at Memorial Hospital, did you receive any pain medications, Tylenol, ibuprofen, anything like that?
Yes.
Do you recall how long you had to be treated before you were discharged?
1 day.
Dude.
You know what? Good for these freaking witnesses. Good for you for being able to do this. Because I don't know that a lot of people could do this shit.
No. No.
In the days after the event, did you file any claim whatsoever?
Can you be more descriptive?
Right back.
You know where the state of Wisconsin is? Soon to be up your ass is where it is.
JFC. Sir, drop it. Drop it. Drop the sovereign citizen nonsense. It's just not working for you. Their inability to observe was enough.
Yeah,
That's
you
your
know how-
defense.
Yes, you know, the cross-examination is 3 questions. Could you see the vehicle? Yes.
Yeah.
What would you say? Like, you would say that your vision was inhibited. You couldn't see the driver. No, I couldn't see the driver. Did you see the license plate? Why the license plate doesn't matter. Did you see the driver? No. Okay, no further questions.
Moving on. Moving on. So you don't
Did
know it was me.
file,
Fantastic.
a claim as an injured party.
Did you file a claim?
Do you remember who that was with?
He's not
No.
the injured
Oh,
party.
no,
The
no, this
injured
gets
party
worse.
is the state.
Wait, Kurt, this gets worse.
Would you consider yourself to be an injured party in this matter?
Absolutely.
It gets worse. Just listen.
So you would consider yourself to be a plaintiff? Grounds.
No.
Sustained.
Kurt, listen.
And
Just
relevance
listen.
grounds. And under 90611 as
I'm
well.
listening.
Do you recall who called you to testify in this matter?
The DA?
Can you point out for the jury which DA?
No.
Did you see him in court?
No.
Came from the DA's office. He probably doesn't even know which DA.
No, true.
Not
Do
that
you
it
recall the
matters
name of the
anyway.
DA that you're referring to?
I got
Judge, as to relevance for this
Grounds.
hearing?
It's a valid subpoena. Doesn't matter which
Sustained.
DA. It doesn't even matter if they're in the
It's
room.
already indicated that the district attorney's office.
They might not be in the
issued
room
subpoena.
for that matter.
Actually, he said the DA, so that was pretty
Kurt.
vague.
Woo saw moment.
Sir, did you mean the district attorney's office?
Yes.
Next question, please.
Were you subpoenaed?
Yes.
Yes.
Do you recall the name on the subpoena?
No.
Grounds.
Relevant.
Sustained.
Doesn't matter.
At this point, I'm looking at Kurt and Artie, and they both have the same facial expression. They're both giving up on life at the moment.
I'm just fantasizing about food I'm ordering in my head at this point to make me feel better.
Yeah, I've got things I'm thinking about, but it's not
So to the
food.
best of your knowledge, you're not aware of any plaintiff in this matter.
At least my destructive
Oh
habits
my
only extend to
God!
Sustained.
Again with the plaintiff BS.
Yes.
Again,
To the best of your
for
knowledge.
every witness so far.
Shut up about the goddamn plaintiff. Enough.
Natalie gonna lose her fucking mind.
It is
Look, we all have weaknesses, and I have no shame of admitting if I become a judge, this might be mine, because I don't know that I can deal with this bullshit. I am just I'm sorry. Maybe it's pompous or arrogant, but I am just way too educated for this crap. I can't deal with it. It is a waste of my time and energy. I can't deal.
Yeah, it's not the pomp. It's not pompous. What it is it is so unbelievably beyond cringe to the point of insulting the legal process and everything about this.
Mm-hmm. I know everything he thinks, and I know everything why it's bullshit, and I just can't be bothered.
Yes.
Let him say plaintiff one more time, and I am going to just explode from my skin. I
Don't
cannot
do that.
take it anymore.
Don't do that,
I'm
Natalie.
losing it.
Natalie, your skin is too important because he says plaintiff way many more times.
Does he say it all the time?
You have never seen the plaintiff in this matter.
Objection,
Grounds.
relevance.
Sustained.
Seen the plaintiff. Seen it. If you want, I'll dig up their original petition for statehood if it'll make you feel better.
It would. Please do. That would make me feel better.
Have you ever seen or read a complaint in this matter of any kind?
Yes.
Would you state what that was for the record and for the jury?
I just saw the stuff in the news.
And seeing stuff on the news would amount to a complaint?
Sorry, I misheard your question. Can you ask it again?
I like the pause. Question.
Have you read or seen a complaint in this matter?
Oh, get indignant, you prick.
But it would be fair to say, just based on your testimony, that you saw reporting on the incident in the news. Would that be fair to say?
Yes.
Do you recall what you saw in the news?
Just information about the trial.
Did you see anything before the reported trial?
No.
Would it be fair to say that this matter has been going on for quite some time, that there were a lot of reports in the news? Would that be fair to say?
This has been going on for some time. There were some reports in the news, that's for sure.
This works unless you can tie it into relevance with this witness. I'm inclined to sustain that objection.
I'm going somewhere with it.
No, you're not. You are absolutely not. I know you're not.
No, you're not. You're not going
Don't
anywhere.
lie. Don't lie. I know you're not.
Have you yourself seen anything in the news before the scheduled trial in regards to this matter?
Yes.
Can you state for the record and for the jury what that was?
For the jury. State for the jury.
Oh, the jury.
Just
5
information
minutes.
about the trial itself.
3.
Did you at any time see any reports about the alleged defendant at any time?
The alleged.
Is hard labor still a thing? Can we do that?
611. This is not a
Make him break some rocks or
Wait,
something?
wait. Hang on. I want to hear this. I don't remember.
You're gonna hear it, but I just want to say that he is calling for hearsay. Did you hear about this anywhere else?
Yeah.
Where? What
I mean, 100%. Like
all
yeah,
he's
and-
doing is calling for hearsay. These,
and
aside from the fact these questions are irrelevant.
The prosecutor has not objected once. Like completely good move.
Why even bother?
Good move.
Yep.
Yeah, why bother? It'll be over sooner if they don't, and eventually the judge will just shut him down because she's tired of it.
Yeah.
I'm struggling. Okay.
A witness who identified the driver, so I'm not sure where the relevance is of this. We'll take it up outside the presence of the jury once you're concluded with your questions, and I'll determine if there needs to be more questioning of this witness. Next topic, please.
Anyone remember what happiness was like? It was nice.
You testified a few minutes earlier that you really don't remember much after being struck. Do you recall?
By a fucking car.
The car somewhat disrupted my
Do you recall
attention.
where you were after being struck?
Probably the same place I was before being struck, to be quite honest.
And
You
about which
asshole.
area? Was it by the Blazers truck, relatively close to the curb, or about what position?
Near the truck.
Near the Blazers truck.
Yes.
Sure, why not? Whatever, I don't care.
Did you see the vehicle strike anyone before it struck you?
No.
No further questions.
How do you read the record?
Pass. Good pass. Good pass.
Horrible. Horrible.
Good job on the
Before
witness and keeping control. So he's better man than me. I'll just say.
Yes.
I have no problem
Yes.
with that. I don't think I could do that. And yeah.
I am rarely speechless. I am genuinely at a loss for words. Genuinely.
I mean, I knew
will-
I knew it was once you got to the victim witnesses, I knew it was going to be bad.
I know.
I just didn't think it'd be this bad.
What's funny about it is that you know that the judge and the attorneys have been preparing for this day. Like emotionally and mentally, they've been preparing for the day when they put their witnesses on the stand. And they've been prepping their witnesses. And as an attorney, you're sitting there just praying that your witness maintains the composure that you've walked them through a million times. And as an attorney, you're sitting there praying that you have the composure to sit there and sit at that table and not give the jury a negative look, not give the judge a negative look, to actually be respectful. And as the judge, you're sitting there and praying that you don't ever have to face this day because somehow this person's going to get the competence to plea to this down, but now you're here.
Yep.
I will say that every person in that courtroom, except for Mr. Brooks, conducted themselves in a manner that I cannot imagine another human being.
The best of our profession.
Yeah.
Absolutely. Amazing. Legal rulings got missed. But
Yeah, well, I mean, that happens to everyone. No judge is
oh
perfect.
my word, that was amazing.
No judge is perfect, and this judge in particular is excused more than most because they're dealing with someone who's infuriating and incompetent and just a total pain in the ass. So I'm going to give the judge a lot of slack.
Yeah.
Well, I'm giving her a lot of slack because she's been giving him a lot of slack too.
Yes. And that is also, just so you guys know, protective of the record, protective of the conviction, because there's been plenty of times she says, I'm not going to help you, Mr. Brooks. And then she turns around and she helps him.
Right.
Maybe this is the question you meant to ask, Mr. Brooks.
Mm-hmm.
I'm not going to explain this to you, Mr. Brooks. And then she
explains it.
I will say, after the first two witnesses today, I would have directed him to not ask any more questions about the plaintiff thing. And I would have
Well, she's done
I would
that.
have said, if you ask that question, she has, but I would have cut him off. I would have cut him off every time he started going down that road. I would have cut him off and said, Miss Brooks, we talked about this. Legal merits, legal ruling. We're not going to do this in front of the jury, and just stop him.
And I think you would have been completely within your rights to do it. But I can think of two really good reasons to not. Number one, I think if he's not allowed to pursue, and it's not like she hasn't tried, but if she gets too forceful in trying to stop him from pursuing the sovereign citizen nonsense, which is what all that has to do with, he will become disruptive again. And this was the first day where he was not disruptive all day. And I know that's not fair to every other defendant who goes into court and comports themselves with the rules of behavior. But
I don't mind giving pro se's a little bit of extra latitude and a little bit extra
Yeah.
help, because
Yeah.
I mean, that's fair, but
yeah. But also he can't complain that he didn't get the chance to take advantage of every single defense available to him and not available to him. That is not a defense available to you, that there's no plaintiff, but okay, that's your strategy. Fine. Here you go. Take your strategy.
It's not a strategy that's legal. It's not a legally cognizable strategy.
It's not.
I don't, as a judge, have to give you a legally defense that's not legally cognizable. And it's not.
I agree. She doesn't. That's why I'm saying Rob is right. Letter of the law, rule of the law. He is right. She should say, "I'm cutting your mic. I'm taking you out. I'm doing whatever if you ask that question again." Right? But allowing him to ask the question up until she stops him from questioning at all is keeping the trial going forward. It really, really is. And it's very annoying and frustrating. But my God, it's keeping things moving.
To that point, kudos to, I know Nick Rekieta did this. I know potentially Criminal did this. I know that other people were Legal Vices has been doing this. To those of you who have been capable of streaming this trial nonstop, oh my word.
I can't deal with this. This is the worst for me, because I like law, and this is decidedly not that. This is some circus theatrics trial level bullshit that I can't be bothered to deal with. I want to deal with these high level questions, the philosophy of things, and he's making a mockery of our entire system. It's like, I don't have patience or time for this guy.
I did it yesterday. Oh, sorry, Ruckle.
Go ahead,
every time I talk about sovereign citizen stuff on my channel, I get somebody in my comments going, "But these guys win on this all the time."
No, they don't.
Because all they hear is
they sometimes win in spite of themselves.
That's
right.
But
because sometimes, despite their idiocy, they are actually correct on the facts or the law. It has nothing to do with them being sovereign citizens. It's just
for all
with the facts and the law.
If this sovereign citizen stuff was correct, and if your points were correct, then what you would see is at the end of this trial, the judge says, "Okay, I'm tossing this for lack of jurisdiction."
Well, well, that should have happened long ago if that was the case.
That's not going to happen.
No, it's not. It's not going to happen at the appellate court or the Supreme Court or any other level.
Yeah, if it does, then you guys are entitled to be in my comment section saying I'm right. Otherwise, you guys are entitled to just shut up. And
the thing is that
sits to your comments.
Go ahead, Artie.
Well, I do.
Go ahead, Artie.
Well, this has always been my wheelhouse, because soft sits have always been my little pet project that I've always.
Oh, good. Well, you can have them. They're all yours.
I debate them whenever I get a chance. Most of them don't like it because I'm a member of the British Credit Registry, but that's beside the point.
Yes, apparently.
the whole
as
thing.
We all are.
But yesterday I went the full gambit. It was like I was on my day off, and I went and I streamed the whole 8.5 hours, only because this is my little niche, sovereign citizens. And this is the first time I'm seeing in a fairly high profile trial somebody try and pull this kind of defense that's not true. Involving that's not involving a traffic ticket, or disorderly conduct situation. So
that's right. And that's what I, again, my hat's off to everyone who has been just live streaming this trial. I completely, anyone who live streams any trial all the way through, I'm always very impressed by that. I just, don't have that ability at all. But the reason I am interested in this case is because I'm fascinated by sovereign citizens. I'm very much interested in just impressing upon people how important it is to have representation of a licensed practicing attorney, and how much I really want everyone to understand that it's important for both sides in an adversarial system to be represented by zealous attorneys who care about their side of the case. And you see why, because, okay, we all know that more than likely he will be convicted, and more than likely the case will not be overturned on appeal. But what is everybody really afraid of? What about the appeal? Oh, will this be a reason for an appeal? What if the appellate court?
No, I appreciate that. I appreciate the judge care, and I appreciate. Although I'd be hard pressed to be this patient, I appreciate they're extending the pro se. So you give the pro se more slack. You do, which is fair. You should.
Yeah.
But I don't know if I could do this much, and I'd be amazed if this gets overturned at this point.
Can I ask? I haven't actually met Artie. Like, this is the first stream I've had with Artie.
Oh, this is so fun.
It is.
Me as well, actually, for that matter.
Like Artie, introduce yourself. I don't know who you.
Who me? I'm Artie of my channel, Artie's Corporate Fiction. I am a licensed attorney out of New York and New Jersey, primarily in New Jersey. I've had my channel. I originally started YouTube doing gaming streams because that's my hobby when I'm not working. But Sovereign Citizens has always been a fascinating interest of mine ever since I actually had a handful of them come across my desk before. And so from there, it came to creating my own channel to separate gaming with Sovereign Citizens. So that's the Corporate Fiction is obviously a play on them always saying everything's a corporate fiction. I have my straw man is a corporate fiction. So that's the play on the channel name. So that's basically been the focus of my content. So for the last couple of years.
And where can we find you? What's the name of the channel?
Artie's Corporate Fiction. That's the name of the channel. Yeah.
I like the name.
We've got to do something because
you want to be part of the law tubes?
Meets with you.
So I do want to let you guys know, because then it seems to me like, first of all, you guys don't know this now that I'm realizing that you haven't met each other before. And so that means the 2,645 of you that are here now, you probably don't know this. Of Artie, I'm going to get choked up, of people around, on this planet alive, Artie is my oldest friend on YouTube.
Oh, that's awesome.
Nice.
Because we
that's
met
amazing.
through the cat.
One of us.
Right?
One of us.
Yes. Artie was one of my first friends on YouTube. We met through this channel called Schrodinger's Cat.
Mm-hmm.
And Schrodinger was not an attorney, but he was a veteran. And he reacted to Sovereign Citizens, First Amendment auditors, and all types of wacky crap here on YouTube.
That name sounds familiar. I feel like I know
he
that
had
name.
100,000, 200,000 subscribers, something like that, Artie.
He had well over 100K.
Well over 100K. And he introduced his audience to me to his audience. He would have a lawyers panel with me, Artie, OPT lawyer, a few other people. And we would get on and react to Sovereign Citizens acting crazy here on YouTube. This is before I ever heard.
I knew Nat when she was sub 20K, or you were
right.
But I saw she
10K.
skyrocketed. 10K. She skyrocketed astronomical.
As well she should. She's
well deserved, mind you. But yes, I'm just saying I'm an OG. I knew Nat before she became famous. So
we've known each other for a long time, and so I always appreciate when Artie is on here. For those of you that know Schrodinger, his passing was just hurt real bad. So I always try to get Artie on this channel. I'm terrible at getting on his because I'm terrible at appearing on other people's channels, but I hope to be on there soon. All right,
I do send the invite. And I'm gonna have to add Artie. I'm gonna add Artie the invites too.
You gotta DM me on Twitter. You've got to.
Do, my dear. Your DMs are just so full of all of your fans. It's crazy. But Artie. I'm adding Artie to my list of DMs, so I just subbed to Artie. So
awesome.
Because I've been missing all the Friday night fun that you've been having over there, Rob. So I'm a little jealous.
Oh, Friday night crazy.
I like the neon. It's a nice look too.
Isn't that nice?
Yeah, that is nice.
That was a birthday gift from the family. Shockingly, they support me in my side channel. So
which is so sweet. Okay, so guys, I am going to get to the super chats. You can stick around if you like, or if you like to do this now, you can sign off. I do see that some people are saying The judge admonished Mr. Brooks at the end of the day today.
Probably deserves
And
it. Yeah.
yeah, apparently people want to see that. So I'm gonna do that before I go to the super chats. You guys are welcome to exit out or stay or do whatever you'd like.
Stay around.
Let me know.
I'll hang around.
I'll stick around for that.
I'm gonna grab
Okay.
another.
You look good in the
glass
tie,
of
by the way,
wine.
Rob.
I do actually have court. Like I am a real attorney.
Yeah.
Samesies.
So
You know, I was about, I probably shouldn't even say this. The reason I've been able to put out so much content recently is because our county is finally switching over to e-filing. And
Nice.
so all of the, administrative people who've been doing everything by paper are getting trained for that these past 2 weeks. So things like have not been getting scheduled that much. So that's why I've been able to be on here. But look at all these lawyers in their suits and in their ties and button-down shirts, and me in my suit. Like literally, we're just some lawyers out here doing it, man. Doing it when we can.
I'm getting results tomorrow.
I wore my frogs
we got
today.
a cufflinks on. I love it.
Ooh, nice.
My froggies. Kurt, results tomorrow? Did they announce it?
Yeah, they announced it this morning that they're going to release it tomorrow.
What a dick move. No wonder you were stressed.
Oh,
you're fine. You're fine.
Wait, what am I missing?
You passed.
What?
Texas bar results.
You passed. You're good.
Tomorrow morning.
You passed. We claim it for you.
Yeah, well, everyone's going to know by tomorrow afternoon because they send me an email in the morning and then they post it publicly in the afternoon. So
that's my least favorite part is them posting it publicly.
Wait, that's a jerk move.
Yeah. Oh, yeah. They post it publicly.
Public record, baby.
Guys, do me a favor, and if you can give me the timestamp, that would be great. But I think she's doing it now. She looks very like I'm admonishing him right now. Let's see.
And just for the record, I have been a licensed attorney in Virginia for like 15 years. So just trying to get additional states in.
Which state are you trying to get licensed
Texas.
in now?
Although now because of the UBE, I'm basically taking the bar in like 23 states simultaneously. So that's the thing there.
I missed out on the UBE.
Yeah.
Yeah.
Same.
I missed out. So you said what, 15 years for you? So what, 12 for me? So yeah.
So if I pass, I might try to, because New York's in it, so I might apply for New York and get inactive, and I'll probably apply for DC because there's no CLE there, and we'll go from there. We'll see how it goes.
I need a timestamp, friends, because I was okay. There she is. Okay. Okay. Let me just get a little bit.
The essays were brutal.
Oh, for me, it's yeah. So you guys know I'm from New York, and but I practice in Maryland. I failed the New York bar by 4 points. They don't tell you how much you pass by; they tell you how much you fail by.
Neither did Virginia. I don't know how much I passed by, but Texas does.
Yeah, yeah.
They announced like the top 3 who are by publicly.
Do you know
so
why they don't tell you like how much you pass by?
Why?
Because it's a bar. It is the lowest rung. That's the criteria. That is the criteria. Right. You have to pass the bar.
No,
it doesn't, because the thing is,
we're all
measuring.
It's you. Well, no, you have to swear fealty to the crown, to the private association known as the British Accredited Registry, and if you don't do that, then you fail.
It's not a thing. Fuck the queen, fuck the king, fuck them all. Fuck the entire British aristocracy. Is that enough for you?
I love it.
God.
We do actually have an oath to the king where I am, which is dumb.
Guys, they said it's past this. Is it past her reading from this yellow paper? This is her admonishing the jury. Is it after she admonishes the jury?
My understanding is that it's after this, after the most recent witness before they go on a mid-morning break.
No, that was the admonishment on hearsay.
Oh, okay.
I think this is actually discharge of jury.
Okay, so yeah, after the yellow paper. Okay, but she's supposed to be admonishing Mr. Brooks now. Let me see if I'm in the right place. If I'm in the right place.
And you know what? Good thing for this judge. She stands up and moves around a lot. Like she's
a good judge. She's a good judge. She's experienced. She knows what she's doing.
Reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the day. We'll see you tomorrow morning. All rise.
Fair
for the jury,
enough.
please.
You go get it, Judge. Go get it.
All right, thank you. Please be seated. All right, Mr. Brooks, I cut you off because I wanted you to raise whatever the issue was outside the presence of the jury. I don't know if you had a question or an objection or a comment, but go ahead.
I have a comment.
I forgot what you. I forgot what part you cut me off on.
Well, it had to do with the one of the exhibits.
Lol.
The second time it's happened where I've told the jury to disregard comments that are visible on the exhibit.
Yeah. Is it a way that? I mean, because that was the one that was the steel frame, right?
Correct. We've seen it before on the video.
Can they cut that part out so that way just make it easier?
That is not a bad objection. That is not a bad objection. If there's comments on a still frame.
For out of state question or an objection or a comment, but go ahead.
I forgot what you. I forgot what part you cut me off on.
Well, it has to do with the.
Sorry, I listened to somebody about the timestamp and they were wrong, and I'm mad at myself. But we'll just have to listen to that part again. Sorry.
Comments that are visible on the exhibit.
Don't worry about it.
Is it a way that? I mean, because that was the one that was the steel frame, right?
Correct. We've seen it before on the video.
Can they cut that part out so that way just make it easier?
So at this point, the exhibits have been received. I've told them to disregard it. What may happen is ultimately when they're deliberating, they may ask to see.
You could always strike it. You could always reverse your ruling.
Then I'll have to make a determination about whether those exhibits are.
So you know what? Never mind. Strike it.
Copies that are there, or shown if
Unreceive it.
That's the type of exhibit we're talking about, and then we'll go from there. So it's a little bit premature, but.
No, you know what? You know what? I don't.
You were more than clear when you told him to disregard.
Unreceive it. It's fine. No big deal.
That part was definitely clear. And the worry would be if they were shown that in deliberations.
We'll cross that bridge if and when it becomes an issue.
That is a good.
It's not a bad objection.
Argument.
The easiest answer here is to unreceive it.
Argument.
Be like,
and he's right.
You know,
he is right.
He is right.
She should redact any comments that are written on the image, because those written comments are 100% hearsay. They should not be appearing on the image.
Correct.
The jury gets to look at the image, not the hearsay.
Correct.
This
so every time when they circled, like the
argument.
witness this is going to when the witnesses were circling things, and they said, well, let's submit that with the circle with the annotation as like 26A or 26B or whatever they said, right? So what he's saying is like strike the annotation. He's absolutely correct. And the easiest thing to do is like she already said it's admitted, but how about like okay, it's unadmitted. A trial judge can reverse their own rulings. They're not bound by themselves. So she could just be like, you know what, I made a mistake, unsubmit it. The jury's not going to notice the difference anyway. Not like they're going to be like in the jury room, worst exhibit 26B. You know, they're not going to care.
For the record, we're talking about exhibit 40. That's the exhibit that Mr. Brooks, the defendant objected to, and then we put on a pause until the jury was out of the room.
It was exhibit 40. We're instructed the jury to disregard the comments.
Hey, hang on. Is the kid sitting first chair?
God bless him if he is, man.
Yep.
Which isn't actually necessarily bad. You know, if he's a somewhat like trained guy, but you know the
you mean the younger attorney?
Like then give the junior guy actually senior chair. I like it.
Yeah, that is not meant to be derogatory. That is, and that is just a sign of my age. I apologize if that sounded derogatory at all. Mm-hmm. The thing is, attorneys I start practicing against start looking more and more like
kids.
children. And the youngest looking prosecutor is sitting first chair in this case.
Well, maybe he's somewhat experienced, and the senior attorney's like, you take first chair on this one, I'll sit second chair, and it's part of transitioning him into, taking more responsibility. So works for me.
I'm hearing some feedback that he's not sitting first chair. That the lady all the way to the right is, but but I don't know. He has a lot of responsibility, and that sometimes is just a designation, because in the murder trial I wasn't first chair, but I had a lot of responsibility. The attorney that was first chair also had a lot of responsibility. Multiple murder, which is what mine was as well. Multiple murder trials. Everyone pitches in. Everyone's got a lot to do. But
everyone has a lot of responsibility. Looking up evidence, feeding things. I mean, they're all important roles. Yeah.
And it may have been maybe the same.
It's the video that the screenshot came from.
Exactly. All right. Then, does the state have any information for me about the witness and whether you'll need the interpreter for tomorrow?
No, we do not believe we will need the interpreter for any of the state's witnesses, Your Honor. We did secure Juan Marquez to be here at noon, so that as soon as we start from the afternoon break, we could take his testimony out of order.
All right. Mr. Brooks, do you understand that?
Object.
But
object jurisdiction.
That since there's the need for an interpreter, and this court had been going through
making the contract for these proceedings,
the clerk's office to make arrangements as it relates to this interpreter. I'm going to have you call that witness. It will be out of order. That's not unusual. That happens sometimes, but we at least have that
it's not a big
witness
deal.
available starting at noon. If all goes well, we'll take an early lunch about 11:30. We'll take an hour, and then we'll put Mr. Marquez on at 12:30. You'll do the initial questioning. The state will then do the cross. Okay? Did you hear me advise you of that?
I'm informed.
All right.
I'm informed.
And then the other thing I just want to put on the record today is that, again, Mr. Brooks does not have the headphones on. I did not notice any apparent difficulties with your hearing. I wanted to also make a record that, especially as it relates to the cross-examination of Detective Carpenter, which I would describe as a technical expert witness, there was some very articulate, clear, cogent, and salient questions were asked by Mr. Brooks, especially regarding when the technology was obtained.
You sneaky little
about such topics as
She's not contemplating.
it was a live case and what that meant. The reliability of the software, the equipment, and the financial.
Oh, I know. Yeah, I've been saying this from the beginning.
No, she's doing her job, and she's doing it very well. God bless her.
Questions regarding did he provide, for example, speed analysis for any other
The epitome of
cases and
backhanded
that
compliment.
nature? You're certainly questioning.
She's very, very good. She's very, very good.
Amazing.
She's murdering his appeal is what she's doing.
She's absolutely murdering her appeal.
She's
making a record of his hearing.
No,
making
like
a record of everything.
Checking it twice.
God bless you, girl.
I want to be clear here.
I want to be Judge Doro.
No, I don't like what she's doing, because here's the thing: if I'm an attorney in that courtroom, I'm standing my ass up and objecting, like to everything this judge is saying, because this is a judge recounting in her own words, from their own perspective, to preserve their record. I am not letting them get a single word unopposed on the record. But this judge is just steamrolling and literally laying the foundation for completely mentally competent to stand trial. Holy shit. Who said that we should wait to see this? Because kudos to them.
Yeah. They're amazing. Thank you to everyone who said to look at this, because I would have totally overlooked it. And because we're looking at this stream has run, I think, probably the longest stream I've ever done in history of life. And so
you're doing great.
Thank you so much. With all of your permission, my wonderful viewers, I am going to preserve the super chats, which I'm currently doing right now, and cover them in tomorrow's stream and thank all of you individually. But I wouldn't feel right after watching this, keeping people for 4 or 5 hours. I just don't think it's right. Although I could do this forever, I really am so enjoying myself. But let's keep up with the judge and what she's saying, because like I said, she's murdering his appeal. That's what she's doing, with kindness, very, very gently.
And murder. Like
And murder. And murder.
This
Like,
is
we
the
can't
sweetest
undersell
murder I've
murder.
ever seen.
It's so sweet.
It's so it's so kind. It's so Wisconsin, you know? It's so like, you know, Midwest, you know, we go to potlucks after church and things like that. You know, everyone is kind to their neighbors.
Is
you
is this
know?
the bless your heart of Wisconsin?
I would say that's
Bless
it.
your heart of judges, you know?
This is the bless your heart. Oh my. Oh.
This is the bless your heart of judges. She's like, you're doing a great job, Mr. Brooks. You're completely competent.
I'm sure you are.
You know?
100% cogent.
You know
Asking
exactly what you're
made
doing.
sense and all of the above. Oh my God.
Questioning other witnesses about whether they've watched videos previously that would go, you know, to their credibility, which is ultimately a jury determination. But
Yes, it
I just
is.
wanted to put that on the record and commend you for that. Any other issues from either
I'm sure you do
party,
want to commend him for
today?
that.
You, sir?
We still got the issue about the 13th subpoena.
Mm-hmm.
So my understanding is you filled it out, or do you need to fill it out?
It's been filled out. I
Has it
I
been?
just wanted to know. I didn't know when it was going to be addressed.
So
And
my understanding, and let me confer with the state, did the subpoena get turned over to the state? The
I don't-
13th subpoena.
I don't believe it has, no.
It's the witness is the one who the state previously advised us was lived out of state. That's the person we're talking about, correct?
and that's the issue.
Yeah, that's definitely what's going to turn out. That
Obligated. I'm just gonna
13th
cut to
witness
the
was
chase. The
definitely
state's
going to
not
help you out,
obligated
you
to make any
asshole.
kind of
Fuck
travel
you.
arrangements or otherwise serve the subpoena on someone who's out of state. There's procedures in the statutes. I'm not going to lay those out for you.
Nor should you.
This is one of those things. I'd refer you back to when we went through the waiver of right to attorney form and about how the court can't explain procedure or the law, that you're put in the same position as an attorney who's been practicing here in the state of Wisconsin. I am not going to require the state to make arrangements for an out-of-state witness.
Damn straight.
That falls on you.
Damn straight. Good for you.
I have to be licensed to be held to the same standard as a
No, you
licensed
don't
attorney.
have to be licensed.
Nope.
You explained
I
that
wanna
multiple
get into
times.
that
You
'cause
don't
I
have to be
don't want you
licensed.
to think I'm trying
No,
to
you
argue.
don't.
With your legal assessment, sir.
No,
So,
you don't.
objections noted for the record.
No, you absolutely do not have to be licensed. You chose to represent yourself.
You know, this was your choice, and actually, no licensed attorney would get assistance with getting a subpoena for an out-of-state witness.
No.
You know, no licensed attorney. Guys, I'm only pausing it because some of you said don't talk over him because it's hard for you. So I know you want him to finish, but we got to give our commentary. So my apologies, but I'm gonna go back and let him finish. Let's let him get through his foolishness.
But you're a party to this case, sir, and parties that
I
are
don't
self-represented can do things that attorneys can do. A party doesn't need an attorney, for example, to secure a subpoena. So with that, I believe that addresses the 13th subpoena. Any other issues?
I intended to have 13 witnesses. So if I'm not obviously
Why
not able
13?
to call the 13th witness, how do I get my 13th witness?
I can't
Why
answer
13?
that, sir.
Would I still be able to have a 13th witness?
You have to name the person. The due date was on Monday. So who would be your 13th witness then, sir?
I would have to look on my original witness list to get the 13th witness. I know that was my target, was 13.
Why
I'll tell you what,
13?
I'll let you look
Why
through
that
that tonight. You can
specifically?
advise us in the morning, and if the state wants to object, they can advise me then. But you're gonna have to fill out another subpoena then.
That's fair.
And
That's fair.
I can't promise that they'll be able to do that, but we'll see what they have to say tomorrow morning.
Yeah, I do want to state also for the record why I'm able to hear you very well is because I'm actually in the courtroom with you, which I have been the last few days, which is
I'm sorry.
breath of fresh air.
I would agree with that assessment, sir.
That's why I'm able to hear much more clearly.
All right, thank you for making that record. I appreciate it. Any other issues from the
That's a bless
state?
your heart.
Nothing, Judge, thank you.
All right, we'll see everyone then tomorrow morning at 8:30. We are in recess for the day.
Holy shit.
Left your little cotton sock, she says.
That is hard to listen to, guys.
That was a bless your heart from the judge, like back to him.
It was. We finally cracked the code of what it is. She had a certain je ne sais quoi, right? We finally cracked the code. It is the bless your heart of jurisprudence. Okay, your objection is noted. It's overruled. We'll see you tomorrow. Have a good night. Sleep well. Law and
Sleep
Lumber,
well.
welcome to the Lawyer Chicklets.
So
I mean,
long,
my
farewell.
Hey, I joined and I gave you some.
Thank you. I appreciate it so much. And your comment will be read tomorrow. I'm just making sure everybody gets a good look at the comment.
No, the
you
comment,
all.
the comment I want read is that was the bless your heart yeah.
Yeah, that was the bless your heart.
That was the
And
bless your heart.
it was beautiful. It was beautiful. Everyone, I hope that you do not hold it against me at all that at oh Lord, what time is it? 9:02 EST when we started at 5:30 EST.
Damn.
I would like to get my wonderful panel home and to bed and on to the rest of their lives. And I would love to stream with you guys tomorrow where I read through each of these super chats in detail. And also we'll cover another topic. So we'll do this as a super chat stream, and we'll do maybe a Q&A, and maybe we'll do some funny videos as a catharsis or a palate cleanser for this case, Mr. Brooks, which is very, very difficult. So if you guys please plug your channels before you go, say whatever you need to say to sign off, and we're going to get up out of here. And guys, if you haven't liked the video, make sure you like the video on your way out. I don't expect you to super chat. I appreciate the super chats, but liking it is free, and that's all I really ask for. Okay, go ahead, guys.
All right, I'll go first. Thank you again, Nat, for bringing me on. This is Artie of Artie's Corporate Fiction. As you guys know, I introduced myself to Runkle Law and Uncivil Law. I have a channel that focuses largely on sovereign citizens and all that craziness. That's why I'm emphasizing this trial. So if you want to know more about the shenanigans, you can come to my channel for that. And beyond that, I'm also a gamer outside of my work history, so that be prepared for that. If you don't like that, well, tough. That's part of my brand. I can't escape it. So thank you guys again. I appreciate it. And again, Nat, we got to do it again. Obviously,
we must.
Take care.
Have a good night. All right, bye.
Okay, we're gonna watch some of the rest of the stuff that I think a lot of you guys are saying that I missed before we close out. My understanding is there was a bit of action involving hearsay that she admonished him for. So I would definitely want to get through that, John. Also, yes, I do lawn mowing videos as well, and cat videos too. So if you're new in the chat, yeah, I do more than lawyer stuff. I have kitties on here. All right. Let me see if this is it.
You really don't remember.
Oh, and cooking streams too.
After being struck, do you recall? Back to if he seen the drive. Of it. The news report.
Oh, wait.
News and
to give me an offer of
Truck, relatively. Struck you.
No.
No further questions.
All right.
Thanks.
Thank you, sir. You may step down.
If you guys have any other points that I should check out that wasn't checked out, that wasn't reviewed on that stream, let me know.
The jury momentarily. We'll let you know when you can be brought back in. All rise for the jury, please. All right, thank you. Be seated. Mr. Brooks, I cut you off when you were asking questions about what this witness had seen on the news. I'll give you an opportunity to give me an offer of proof as to why you believe that's relevant and specifically as to this witness.
Well, it's relevant because of how close he testified to being away from the vehicle. He testified to being 20 yards away from the vehicle, which is not super close, but it's not far enough that you wouldn't be able to see a driver or see into the car.
Well, so that's an argument, sir. So what questions would you have that you didn't already ask, and why? How does the news reports relate to that?
Maybe he may have seen the alleged defendant on the news, and maybe that may jog his memory back to if he seen the driver.
But he testified he didn't see the driver. So
he also testified to never making the comment that he didn't remember the event, but it's clearly in his summary and in his report that he said that. So it's conflicting. His report is conflicting with what he's testifying. So I was trying to get at the credibility of it. That was my whole aim.
What does the news reports have to do with that, sir?
The news reports are relevant just by the sheer amount of reporting that they've been reporting. This has been going on for a year.
That assumes facts, not an evidence, sir. So this witness did not identify you during this trial. This witness testified as to his observations regarding the date in question, his injuries, and other things surrounding what he saw and heard and what he didn't see and hear. So the news reports don't have any bearing on his credibility. The points that you bring up are arguments that you may make if you choose during your closing arguments. But the questions you are asking don't further that theory. So that's why I cut you off, because there was not anything that you were connecting by way of relevance.
With all due respect, Your Honor, a lot of the questions I ask are objected to. It seems like I can't even get to the questions that need to be answered.
Sir, many of your questions go to these sovereign ideas that are frivolous arguments about the plaintiff and all of that. We give you a little bit of leeway. I give you a little bit of leeway on it, but to ask about a claim, because frankly it's a vague question, and many of these victims may in fact have made a claim with crime victim compensation, and so I think that's potentially relevant, but you may be asking it for a different purpose. I'm allowing it probably for a different purpose than you're anticipating, but the questions about the state and the plaintiff other than when you talk about and you ask questions about who subpoenaed them, have they reviewed anything in preparation for their testimony, those are all fair game. But other questions are not, and that's why there's an objection, and that's why I rule the way that I do. So ask relevant questions, they'll be answered. So I don't see any need for this witness to be brought back in. I don't believe that witness was on Mr. Brooks's list, so that witness is excused. Who's the next witness?
With all respect, on the record, Your Honor.
I've asked a question of the state. Let them answer, please.
Mr.
Brooks, let them answer. Hold on.
So the next witness that we had intended on calling is Detective Mike Carpenter with the Waukesha Police Department, who would provide testimony about his conducting the speed analysis of the vehicle. I don't expect that we'd be able to get through direct. Well, we might be able to get through direct.
I'd like to at least have him start. I want to go closer to the lunch hour today.
So the other issue is that we thought we were going to be breaking for lunch, so he's not in the building right now. We have another witness who is ready, who we could call out of order, but that would be moving into a new topic, a new group along the parade route. So we're fine with whatever the court wants to do.
I'd like to keep going, so I'll defer to you on which witness to call.
And Your Honor, I would just note, I don't believe I asked for it, maybe I did. Jeff Rogers, I know he has remained in the courtroom, he is a victim. Is he excused from his subpoena? He was not an individual who we were provided a subpoena for by Mr. Brooks.
He's excused.
Thank you.
All right, we'll bring the jury back out and you may call. Quickly, Mr. Brooks.
You made reference to questions I asked, and being, you said something to the effect of sovereign things. I don't understand what you mean by that. I have no anticipation on your rulings. I'm not trying to sit here and I got enough work to do on the fly. I'm definitely not trying to sit here and trying to anticipate what will be objected to, what will be ruled on in any way.
Sat Hale just super chatted with 100. They said my soul is hurting a bit. Here is a distraction.
Thank you, Seth Hale, for the $100 super chat, and also to you newcomers. I apologize that this is also something that happens on my live streams. I should have warned the newcomers. Thank you, guys. Thank you, Southwell, for the $100 super chat. Let's rewind 5 seconds so we can remember what we heard from what he's trying to argue.
Will be ruled on in any way. I'm merely just. It was understood that this would be a whole new thing for me to do. I apologize if I'm not as polished as I should be, working on 3 days' time before a trial. We see all the work that I have that I haven't even gone through.
Mr. Brooks, the jury's coming back in.
For the record, I don't consent to that name, and I don't consent to the arguments that the prosecution made. There are relevant questions, as the jury deserves
Brooks,
to know.
Please.
Oh, stop!
To know who the plaintiff is in this matter.
Stop! Oh my God, he did do this in front of the jury, didn't he?
They should know who the plaintiff is.
So your objections noted for the record.
Will legal finding of fact on that ruling, Your Honor? Or is that a judicial determination, Your Honor?
Oh, shut the fuck up!
Thank you, everyone. Please be seated. All right, the state may call its next witness, please.
The state calls Alyssa Gajewski.
All right. Good morning. If you would please make your way to the witness stand, which is on my right. It is up a riser. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, will swear you in. Do you solemnly?
Somebody recommended it. Who was it? Scythe DK recommended this clip as well.
Are you referring to the night of? Are you referring to the night of?
Yes, when I'm guessing you saw her at some point that night.
I did not see her that night.
Did you see her at any point?
I did. I was there at the hospital the first day she was able to have a visitor.
And were you told directly by medical professionals at that time that you were able to see her of any possible injuries?
I wasn't told by them. She actually called me.
Can I strike that answer for hearsay, Your Honor?
No, you asked the question.
Nope.
But the answer was hearsay.
Doesn't matter. You. He gave it. They didn't object. And then here's the other clip. Thank you, Sam, for joining the membership. I appreciate it. What? Wait, what? It's a broken link, it looks like. So unfortunately we can't look at it. But thank you, Thea, for upgrading your membership to Sovereign for the tier 2. But yeah, I don't know. I don't know what happened to the clip, the other clip that I tried to play. It wouldn't play. It just ended. Let me try it one more time. Yeah, it's not working. I'm not gonna go to that witness's testimony where she apparently breaks into tears. That's just too much for me right now. But we're going to have to deal again tomorrow. I'm not going to be able to live stream it. I might try and give a brief. I might go live during my lunch break and give a brief take. So far as to what we've been hearing. I did do that, Sheik. If you look at my earlier live streams from last week that talked about it, I did talk about his early stuff when he was still in his jumpsuit, mind you. I'd refused to put on civilian clothing. I don't know what part of the. You're gonna have to give me the timestamp to where he allegedly starts, weeping again. I don't know when that happened. Again.
Are you referring to the night?
I'm not gonna spend the whole time going through the full gambit of testimony for today. I mean, I really don't fucking. I'm gonna swear. I really don't fucking care about him apparently crying again. I really don't. So I really, I just don't. I mean, we already saw him cry before. I couldn't care less about him crying a second time. So we're gonna stop here. Yeah. So like I said again, I Monday was a fluke. I had off that day, so I was able to live stream it. I can't do it throughout the rest of the week, unfortunately. But I'll try my best to give at least a brief take on what was going on at lunchtime tomorrow, maybe, hopefully. And then obviously I'll probably give a brief take in the afternoon. I'll try to go on live as much as I can, as early as I can. So assuming the trial is still going on at 5 o'clock, I'll probably be live to catch the tail end of that. So catch me out there, guys. So yeah, look for me tomorrow at lunch, and then at noon Eastern, and then tomorrow at 5 o'clock Eastern. And yeah, I want to thank you guys again for watching. The cats are currently staring at my soul because they need food, so I need to go take care of that. All right, see you guys later. Adios. What? Now! They're being a bunch of bad kitties. All right.